Good afternoon. Today is February 4th, 2026, and welcome to the House Judiciary Committee. Because he loves us so, we are going to start with Delegate Kaufman, and we're going to hear House Bill 330, and with him is Michelle Siri.
Good afternoon, Judiciary Committee family. It's always a joy to be back with you. Good afternoon, Chair Bartlett, Vice Chair Davis, and distinguished members of the committee. For the record, my name is Delegate Aaron Kaufman. I'm going to go into some detail later in my testimony, but the bottom line is the work of the Maryland Legal Service Corporation and the work of the Maryland Legal Service Corporation Board has grown exponentially, as I'll detail, because we've given them additional responsibilities, and the board composition has not changed in quite a while. So to ensure that poor people continue to have access to quality justice, and that the MLSC board continues to be the gold standard of board governance, we need to increase the number of board members they have from 9 to 12. It's a modest but important structural change to expand the board MLSC board of directors from 9 to 12 members. The Maryland General Assembly established the MLSC in 1982 to administer grant funding for civil legal services using proceeds from the state ITOLA account. Under current law, the corporation is governed by a 9-member board appointed by the governor. At the time of its creation, MSLC oversaw a relatively small number of grantees and programs, so the smaller size worked. Over the past 4 decades, MLSC's role has expanded substantially as the General Assembly has repeatedly entrusted the corporation with additional responsibilities regarding access to justice in Maryland. MLSC's grant network has grown from just 5 organizations to nearly 50 legal service providers operating across the state. These organizations deliver legal assistance in areas including housing, stability, domestic violence protection, consumer law, public benefits, and family law, often serving Maryland's at their moment of acute crisis. They do more, but I'm just trying to stay within the time limit. More recently, the General Assembly has assigned the MLSC major new programmatic duties, including administration and oversight of the Access to Counsel Eviction program established through legislation in 2022. The program has significantly expanded MLSC's operational footprint, fiscal oversight obligations, and coordination with courts, legal services, and state agencies. MLSC's board members carry significant and substantial fiduciary and governance responsibilities. The board is responsible for overseeing grant agreements, monitoring compliance and performance, ensuring fiscal accountability, and setting strategic directions for a statewide legal organization that is one of our premier organizations. As the number of grantees, funding streams, and statutory responsibilities increase, so has the workload. So my bill recognizes this growth and responds accordingly. Expanding the board from 9 to 12 members will strengthen governance capacity, distribute oversight responsibilities more effectively, and most importantly, in my view, allow the board to draw on a broader range of expertise to meet the demands of a growing organization. Importantly, this bill does not alter MLSC's independence, mission, or appointment structure. It simply ensures that the board is appropriately sized to carry out the work that we ourselves have given them. So I urge a favorable report, because we all know how MLSC and its partners are the gateway to justice for the poorest Marylanders. So I thank you so much, and I'll be happy to answer any questions.
Thank you so much. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Michelle Siri. I'm the Executive Director and CEO of Maryland Legal Services Corporation, and I really can't put it any better than Delegate Kaufman just did. I will simply add that our volunteers, or our board members, are all comprised of volunteers. I will also add that the Governor's Appointments Office is completely in support of this, and perhaps most importantly, there is no fiscal note and no other cost to the state whatsoever.
Thank you very much. I will say, when I was reading it, I thought, okay, where's the problem? Where's the problem? I kept looking for the problem. Did anybody else find the problem, members? All right, no questions? All righty. Thank you very much. Did you want to say something?
I just think
Delegate?
I've outlined the problem for you, so.
Well, thank you. Will you-
No, that's fine.
Thank you, Delegate Kaufman.
You've always a joy to see my judiciary family.
And
I'll be back
likewise.
several more times this session.
Oh, good.
I will not.
Come back anytime.
Thank you very much.
Thank you. That was great.
Thank you for your indulgence.
Have a great day.
You too, Madam Chair.
We're going to move on to House Bill 286. And I believe we have Christine Nizer from the department. Okay, great. And do we have Mr. Hill online? That was a no? Okay. All right. Ms. Nizer, whenever you're ready. Thank you.
Thank you so much, and good afternoon, Madam Chair, Vice Chair, and distinguished committee members. For the record, my name is Christine Iser, MBA Administrator, and here to testify in support of House Bill 286. House Bill 286 modernizes our existing ignition interlock statute by allowing drivers who are over the age of 21 who have violated an alcohol restriction on their license to enter the ignition interlock program without having to go through the courts. Under current law, the MBA's authority to enroll drivers into the ignition interlock program is differentiated based on age. So for those who are under 21, they do not have to go to the Office of Administrative Hearing and go through that process. They can opt into the ignition interlock program without the expense and time of that happening. All we're asking for under this change to statute would be to allow those who are over the age of 21 the same process. That will save both time as well as the court costs for the administrative hearing and further get people into the program more quickly, which aligns with our public safety mission and the definite policy direction that this legislature has made in terms of ignition interlock being an effective way to curtail impaired driving. So for all those reasons, removing this outdated administrative hurdle, we believe, not only saves time, but it has life-saving benefits. For those reasons, MVA respectfully requests your favorable consideration. Thank you.
Thank you. And Mr. Hill?
Good afternoon, Madam Chair, and sorry, I was jockeying between JPR and here. I've got two bills at the same time, but thank you for hearing me. It's Robert Hill on behalf of the Maryland State's Attorneys Association. I'm a prosecutor with Montgomery County. And my understanding, I was involved in some of the recent interlock bills requiring persons who received PBJs, first-time offenders, to be involved with that. I thought it was very important to have wider participation. I think the effect of this bill will eliminate the hurdle of people over 21 who have violated, or they have a restriction now on their license, to have to go and have an administrative hearing. I think it lowers that barrier, and I think ultimately it will save lives because, unfortunately, people will drive anyway. But if we know that, let's make sure it's easy for them to get into the interlock program. And so for that reason, I would urge a favorable report. Thank you.
Thank you. And thank you for toggling between us and JPR. We appreciate that.
Thank you, Madam Chair.
Are there any questions, members? Delegate McComas.
I'm working on my quota. Anyway, hi, Ms. Nizer.
Good afternoon.
We go way back. Anyway, my question to you is, as we progress with the cars and the self-driving cars, do you feel that we will have something that before you can start the engine, you have to blow and it won't, the car won't start if you're over the alcohol limit?
So
And how
technology
soon is that
exists
gonna happen?
today. It's called driver alcohol detection system for safety. It's actually something we piloted here in Maryland on some state vehicles. And so there's different models. One is through touch and the other is through your breath. It's a passive device as opposed to the active device with the ignition interlock. We certainly think that's something they are looking at the federal level as an option to be in vehicles so that individuals are aware when they're impaired. We obviously, our message is don't drive if you've consumed anything, but certainly more education is better. So it's a technology that we certainly believe will help continue our reduction in fatalities. Proud to say that we reduced fatalities on our roadways last year 18%, but it's an ongoing struggle to make sure that we get our goal of Vision Zero. So certainly technology is one way to do that.
Another quick question. From what I understand, there's also the problem of a lot of folks driving that are under the impairment of drugs or maybe marijuana. Has there been any progress on that front?
Certainly, we recognize that with legalization of cannabis, that individuals could be consuming. I will say there is no standard nationwide test in the same way that BAC has emerged as that test for alcohol. It is something that, as a highway safety community, we're actively working on with our law enforcement partners. We do a lot of training, and there are things called drug recognition experts who are trained to understand the signs of impairment, but we're not yet at that test that has a distinct level to it. And so, generally speaking, we see a lot of multiple use, so it might be alcohol and something else. Generally, once that legal limit has been met with alcohol, there's not necessarily additional tests done unless there's fatality involved, and in those cases, oftentimes there are additional tests.
Thank you, Madam Chair.
Thank you.
Thank you.
Delegate Conaway.
Thank you, witness, for coming in to testify. Did you say something about a touch test?
Yes, Delegate McComas was asking about future technology. It's not part of this bill, but I was just answering in terms of technology that's being worked on at the national level to allow you as the car driver information about your impairment level. So it's not an offender program, but rather through touch, it can sense the alcohol in the system, based on, what your skin touch, and then also the passive breath.
But is the touch technology available now or still in development?
So it is in use in certain fleets, but it's not commercial use yet.
Thank you very much.
That's pretty cool. Okay, thank you very much. That concludes our testimony for House Bill 286.
Thank you.
Thank you, Mr. Hill. All righty, we're going to move on to another departmental bill for House Bill 284. We have the Maryland Department of State Police, Catherine Kelly, Donald Pickle, and Andrew Rossignol. And Ms. Kelly, whenever you're ready.
Thank you, ma'am. Good afternoon, Chair Bartlett, Vice Chair Davis, members of the committee. For the record, Catherine Kelly, Department of State Police Government Affairs Unit. Today, I have with me Captain Rossignol and First Sergeant Donald Pickle of our licensing division. It's a pleasure to be here today to testify in support of our departmental bill, House Bill 284. The bill seeks to require a licensed regulated firearms dealer when there is an event that compromises mandated security features to notify the Secretary within 24 hours of discovering the compromise. The reporting requirement is in addition to reporting of any crime or attempted crime to local law enforcement agencies or the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The measure is not intended to interfere with any investigations or to impact business operations of licensed dealers. Simply, this bill is intended to ensure the integrity of required security features, that they're maintained by making sure there's a timely notification of a compromise. At this point, if it's okay with the chair, I'd like to ask Captain Rossignol to describe the notification process and what it will look like.
You can do that, but you're not yielding your time, are you? I mean, you're not gonna, do you have more testimony?
No, ma'am, it's a very simple bill.
Okay.
When he's finished, we're going to ask you to please support our bill.
Okay. All righty. Captain?
Yes, madam. Thank you very much. Appreciate it for us having the time for us. The notification process is intended to be very simple, streamlined. As of right now, we're looking for just nothing but an email, telephone call, text message, live help. Ultimately, in the coming months and years, we're going to automate this with the click of a button. So we're not trying to make it too complicated whatsoever.
Mr. Pickle, no testimony?
He's
Here for questions?
I'm here for questions, ma'am.
Great to have you. Are there questions? I suppose not. You said it was a simple bill. Thank you very much for coming in.
Thank you,
Appreciate it.
ma'am.
Thank you.
Next, we're going to have Delegate Griffith. Oh, there you are. Welcome back to Judiciary.
Madam Chair, can I ask, we're signed up in opposition to the bill?
You're signed up in opposition to 284?
Yes.
Well, then, I'm sorry? I'm hearing different things. Hold on one second.
Pika and Mark Pennock.
Oh, I see. That line threw me off. I see. You are signed up. My apologies.
Thank you, Madam Chair.
My apologies.
So,
You go
I'll go first, okay.
And Mr.
Thank you,
Pinnock.
Madam
Mr.
Chair and members of the committee. John Pika on behalf of National Shooting Sports.
Thank you, and you know that was not intentional. I just have,
A gun bill in Judiciary?
no, I just have a line here that threw me off, but
Thank you, Madam Chair.
please proceed whenever you're
Thank
ready.
you very much. National Shooting Sports Foundation, otherwise known as NSSF, is the nation's trade association for hunting and shooting sports. We represent stores and manufacturers. We work closely with Captain Rosignol and First Sergeant Pickle, as well as Miss Kelly. And we really we don't have strong opposition, but we want to work with them on the language. The ATF under federal regulations already requires reporting theft or loss, and it requires that report also be submitted to local police. But about 3 years ago, maybe 4 years ago, the then Speaker Adrian Jones had a bill that passed that required security features at all stores and with all FFLs. And the state police, now that they regulate those stores, would like to know if there are any issues related to security that have occurred. So there are the language in the bill is a little bit broad, maybe even a little vague. We'd like to work with the state police to make that language a little clearer for the dealers. And that's all I have.
Okay, thank you.
Other than we work very closely with the state police, and we would like to work with them on this bill as well.
Sounds good. Mr. Pennock?
Thank you, Madam Chair. Mark Pennock, President of Maryland Show Issue. I join in the high regard for the current administration of the State Police, the Licensing Division, Captain Rosenthal and First Sergeant Pickle have been exemplary in working with dealers. This is not meant to criticize them in the slightest. But the language of this bill piles one ambiguity on top of another. It doesn't even require an actual compromise. It doesn't even require actual knowledge that there has been a compromise as a feature. Well, I think the bill can be streamlined and so that the potential for unnecessary and stringent punishments, $1,000 in suspension and revocation of the license of this dealer, this livelihood, can be focused more on language so they actually knew of something rather than should have known, that it requires an actual compromise to the security provisions rather than may have compromised the security provisions. So these are sort of things that the language is way too broad in imposing what could be severe sanctions on the dealer. I don't think it's necessary. We appreciate the intent of the bill and the requirement of being reporting. We don't object to that, but the language should be ironed out so as not to accord so much unbridled discretion to the enforcement agency. That's all I have.
Great, thank you. So the actual knowledge that you're speaking of is in the bill, but it's that may have been compromised is the language that is the.
Should have known. It may have compromised and should have known.
No, it says, right, it says a licensed dealer who knows, that's the actual knowledge.
Actually, Madam Chair, it actually says that A licensed dealer who knows or reasonably should know.
Right, I was putting a pause there for emphasis.
Okay, I'm sorry.
It says a licensed dealer who knows. Isn't that actual knowledge?
No, it should have known means that he didn't know, but in the circumstance.
No. Isn't a licensed dealer who knows actual knowledge?
Yes, of course.
Right, and then the or reasonably should know, that part is the part that you're saying is confusing.
Yes,
Okay.
it's very vague, plus the may have compromised language on top of that.
Yes.
And the event, that's undefined term. So
Yes.
it can be a burglary or some event, and the event is not defined. So we have one ambiguity piled on top of another in terms of the enforcement discretion. And Maryland law is quite strict about this in terms of giving unbridled discretion to law enforcement on something, on a bill like this. It requires definitions and some certainty so the people who know that they're being subject to this requirement know what's required of them.
Right, and so would you like for the compromise to be defined?
I'd like to see a may have, a reasonably should have known struck. I'd like to see actual compromise rather than may have compromise. I'd like to see event defined.
Okay, and so one more question. So the actual compromise requirement could very well relate to or translate into loss of life or injury with the actual compromise, if you have to wait to prove an actual compromise. I thought, it seems to me that the point of the bill, the may have been compromised, is so that they could be an inspection, they could find out if there has been an actual compromise.
Well, that's not the recording requirement, Madam.
I'm sorry?
That's not the recording requirement. This bill is written, requires reporting on something that he should have known may have been compromised. So
Right.
a dent on a barrier by a car is a compromise, but it's not significant or may not be significant. And how is he supposed to know if he should have known that? So
Okay, so you know what, I'm not going to be in the meeting unless you all want me in the meeting, but I honestly believe that you all, like you said, you're much closer than you think. There's just a couple of words maybe we could strike, but if you all would please meet and come to an agreement, that would be great, and it'll make our lives a little bit easier.
I would be pleased to participate. Thank you.
Thank you so much. Delegate McComas?
Just briefly, I knew somebody that had a computer store, and they would have issues with the security system, and it would go on the fritz, and either it would call the police or it would call the fire department. And my concern is that things do happen, and so you could have notifications that are bogus, you know, for electrical reasons or whatever. And my concern is that people would get stuck for $1,000, and it's not really their fault. It hasn't been an intrusion or a botched burglary. It's just that the system didn't work. So I would want to make sure that is part of the thing, that in other words, it's investigated, but they're not going to get hit with any fines.
I think I can answer for the state police. I think this only applies to these security features on page 2, between lines 4 and 8.
Okay.
If those features have been compromised. So there is something on the security screen, but I don't think that's going to be a problem.
And if I may add to that.
Well, the example I'm giving happened quite a few years ago, but the point is it was a problem, and it was a problem for the business.
So the original bill, it's not in my written testimony, but as current law is that if the security feature, like as we're talking about monitoring system and camera system, it fails for no fault of the dealer. And that's already current law, and that's certainly acceptable.
Thank you.
Thank you. Delegate Arica.
Thank you, Madam Chair. I'm just volunteering to be in the meeting to help facilitate this.
You're most welcome.
So, yeah, if you need somebody in the meeting, I'll be happy to be in the meeting with you guys.
Thank you.
Yeah.
All righty. So now that concludes the testimony for House Bill 284.
Thank you,
Now,
Madam Chair.
Delegate Griffith, thank you for your patience. Delegate Griffith, House Bill 208.
All right. Talk about an easy bill.
What was that? I'm sorry?
Talk about an easy bill. I got a very easy one.
I was going to ask, is it just you today?
Just me. There's
All right.
few people
Whenever
who
you're
submitted written
ready.
testimony, but
Whenever you're ready, we do have a favorable with amendment. Is Zafar Shah here? Okay.
oh,
Do you all, Would you mind if you all are
Not at all.
together? Okay,
Not at all.
great.
All right.
So whenever you're ready, thank you.
Thank you. Thank you, Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. For the record, my name is Delegate Mike Griffith, and I'm respectfully requesting a favorable report on House Bill 208, Courts Evidence Proof of Ownership of Real Property. So essentially, the problem we're trying to solve here, and this kind of ties back to some of the issues we are dealing with squatters. So we're looking for different ways to deal with this issue without being punitive or getting people caught up in the legal system, and we think we have found one here. So when somebody takes possession of their home, they close on the documents, and they go to their house with keys to move in some cases they're discovering there are squatters in the home. So of course, then they go to the courts and try to begin the process of evicting those squatters. Well, what happens is in some jurisdictions, it can take 2, sometimes up to 6 months for the deed to be recorded in land record, just because of backups and a number of other factors, right? So in some cases, judges are deciding that, well, you have a signed contract. We know the deed's been submitted to the clerk of the court or the clerk of the court, but it's not recorded in land records. Therefore, we don't recognize you as owning the home, and we cannot begin the process until it's recorded in land records, which could take months. And we think that's unfair. And in all other matters, as far as I'm aware of in the judiciary, if you have proof of ownership, right, the judges rule that you own that property, but for some reason not with real property in some cases, not all cases, but in some cases. And this is becoming problematic for individuals trying to move into their home. So all this bill seeks to do is state that if you go to the court to say you own the property and you have proof that you've closed on the property, a contract, and proof that the deed has been submitted for recordation, then the judge must recognize you as owning that real property. And we don't think that's far-fetched. We don't think that's a radical departure from the law in any stretch of the imagination. With that being said, we did have multiple conversations with the clerks of the court, and they had a couple recommendations for amendments that we would see as favorable. For example, on paragraph B2, because the intake sheet is not recorded with the deed, they want to change that language. They also recommend retaining county finance office in the bill, as those offices are often the first to receive land records and are frequently where recording delays occur. To address these points, the clerk suggests friendly amendments to clarifies that the evidence of submission of a deed or required real property documents to either the county finance office or the clerk of the circuit court may be used to establish a presumption of ownership. So again, all we're trying to do is just allow folks who own their property to be able to be ruled in their favor that they own real property. Sorry, stop there.
Thank you.
Thank you.
Mr. Shaw?
Chair Bartlett, members of the committee, Zephyr Shaw from Maryland Legal Aid, and we appreciate the intent and spirit of the bill. Maryland Legal Aid represents hundreds of low-income homeowners across the state and thousands of renters. What we see, for instance, in our thousands of eviction cases is that the district court does not hold plaintiffs to a very high standard in proving their case. The risk of this bill, in our opinion, is that because it expansively applies to any court proceeding involving real property, it could have a detrimental impact on tenants who are in a fair to pay rent case or a tenant holding over case, not just wrongful detainer cases where that allegation of squatting might come up. So one of our proposals and amendments is to really just cabin off those district court proceedings where there is no discovery, categorically no discovery in fair to pay rent and tenant holding over cases. There is not a discovery in a wrongful detainer case either, and I leave that for the committee to contemplate. A tenant or an occupant would not be able to rebut a presumption of ownership as suggested in this bill because they don't get discovery, nor did they have much time to prepare for that case. Our second amendment, proposed amendment, is that rather than any documentation that could show or could raise that rebuttable presumption of ownership, really limit that to a signed and certified judicial form that a clerk would, where a clerk would certify that there was a perfected filing of the recordation of the deed. Forms like the HUD-1 settlement are forms that may not signify that there was actually a closing or that there was a recordation at all. So we're just trying to cap that off. And I think I'm happy to answer any questions, and we urge a favorable report with amendments.
Great. Well, thank you. So I have one question for you, Delegate, and that is, I was looking for the clerk's amendments, and I don't think it was submitted. Can you submit that to the committee, please?
I can. They did not submit a formal amendment, but they did submit it to my office. I'm happy to share that.
Yeah, that would be great. Have you requested the amendment already?
I have not.
No. Okay. So if you, yeah, if you want the amendment, and if you want Mr. Shaw's amendment, will you go ahead and please request it?
Absolutely. And the intent of the bill is to deal with wrongful detainer situations, we don't want to inadvertently capture all matters. So I certainly would see his amendments as favorable as well.
Okay, great. Delegate Corrigan.
Thank you, Madam Chair. Thank you very much, Delegate Griffith, for the bill. First of all, when you're working together on those amendments, you'd said you weren't worrying about the wrongful detainer to the gentleman on the right. Just make sure that that the amendments that are requested capture what he's trying to and what you don't really care about, because you'll be the expert in making sure that happens. My question for you is, when you're dealing with a tenant holding over, if the property's been properly been sold and the new owner's there, the new owner doesn't have a contract at all with this person. In fact, this person who's renting may actually not even have a contract with the previous owner, or not have had contract for months or months and months. Why should we be protecting them when this new owner should have full rights to be able to use it in quiet enjoyment?
Well, let me just correct one thing first, Delegate Card, is Maryland Legal Aid has strong considerations about wrongful detainers and the type of punishment that victims of rental scams face in wrongful detainer. We covered that last year in SB 46, which this committee substantially revised and got that done, in our opinion, very well. In a tenant holding over proceeding, like any summary rapid process in district court, we think that the plaintiff's fundamental duty in court is to be able to use the best evidence to establish their standing. And so if they don't have the deed, that is such a primary part of establishing their case in a summary proceeding. We don't think it should go forward, and we would want to dismiss that. We want the court to dismiss that case. So okay. you might not feel that the defendant has a leg to stand on, but the court must certainly establish, the prima facie elements. I think Delegate Griffith's solution, especially if it were strengthened with a certified judicial form from the clerk about a perfected filing of the deed for recordation, I think that would solve the situation you're concerned about in tenant holding.
Completely understand. Now I understand that your issue is procedure, not whether there's any technical rights of you just want to make sure that the procedure is done properly as has already been established, and we don't want to mess with that right now.
I think that's a good way of saying it.
Fair enough.
On the scale of thousands of cases, the procedures really matter. Thank you.
Delegate Conaway.
Testify. So Delegate, how many amendments are you proposing? 3?
Well, I have 2 amendments from the clerks that I would see as friendly, which I think those amendments may in part address your issues. And then I'm looking forward to receiving this gentleman's amendments. Again, we're just trying to solve the problem without having any unintended consequences. So if between legal aid's amendments and amendments from the clerk, we can find a good position to move this bill forward, I'm happy with that.
So maybe that's three or four amendments.
Potentially.
And what's the cost of these deeds that will be issued by the clerk?
This is already, for the clerk's portion, their amendments, this is something they already do. And they would, upon request, they would provide proof of submission of the deed for the purpose of recordation.
They already do this?
And that would be, and it will only be in situations where these are requested, right?
Right, okay.
So it's a situation where, say, I go to move in my home, I have my keys closing, there's a squatter in there. All right, well, I need to go to the court, I'm gonna get my letter from the clerk saying I've submitted the deed for recordation. I already have my signed contract saying I own the property, and then take that to court and have the judiciary recognize that as I own the home, while I'm waiting for that deed to be recorded in land records.
And you're saying currently you can get that from the clerk now?
You can. Again, their recommendation was to, instead of create a brand new process, incorporate some of the things they can already do now.
Okay, thank you so very much.
The Vice Chair.
Thank you, Madam Chair. I understand this is a big problem, and we've tried several ways to try to figure it out. But it's not as clean cut as you're making it. A tenant holding over and a wrongful detainer are two different things. The tenant holding over has rights. And for instance, if I just wanted to kick out my tenant holding over without following through on the legal rights and the legal procedure, I'll just sell it to my daughter. And then she gets that piece of paper and she walks in under this law. She walks in and can kick her out. So we're going to have to make sure that we stay within the law. But
Well, again, the focus of this bill is wrongful detainer. Any language to help make sure it's focused on that, I would see as favorable.
thank you.
Delegate Embry.
Thank you. And like many have said, this is an important issue, and I appreciate the bill very much. And the amendments all sound like they're in the right spirit. I was reading the Judiciary's opposition, and one of the things they say is that it is now possible to record the contract of sale, pay the recordation tax, and use that as proof. Is that correct? Is that not sufficient?
What I know for a fact is, because I'm in title business, right?
Yeah.
And we have had clients who've been told by the judiciary, there's some judges who have ruled if it's not recorded in land records, they will not recognize it until it's done. And in some jurisdictions, it takes 2 months, sometimes it takes 6 months for a variety of reasons. And because judges are actually ruling that if it's not in land records, they're not going to recognize it, we're trying to find a way to preempt that.
Well, I just suggest maybe at least talking to the Judiciary, because if this isn't rule, then and it's not being enforced, that might be something they need to do on their end.
Again, it goes back to, in this committee, one of the first lessons I was taught is not to allow the judiciary to interpret the will of the General Assembly. So if we're very finite and very specific in how we want things to be interpreted, that keeps everybody, on the right track.
No, I understand, but if they have a Maryland rule and they're not complying with their own rules, is my question.
Again,
I just don't know.
That's outside my.
Thank you.
Yes, ma'am. Thank you.
Mr. Shaw, do you know?
No, I do not know about
Okay.
what the judiciary is testifying about.
Okay. Delegate McComas?
I would just request Delegate Griffith and you as well, if you could just give us the amendments that you want, because I have somebody that knows a lot about landlord-tenant law in the district court and has had a great deal of experience, and just to kind of get their spin on it, that whether we take care of the problem and specifically what the problem is you want this to solve, so that we won't be back here again and again trying to fix it, because it is a problem for the landlord and it is a problem for the tenant, and we got to find so we can move forward, both parties can move forward. Thank you, Madam Chair.
And just for the record, our amendment sheet is page 3 of our written testimony. I'll share that with the delegate.
Thank you.
Thank you, everyone.
Okay, thank you very much. That concludes the testimony for House Bill 208. Next, we have House Bill 126, Delegate Pippy. And Delegate Pippy, it looks like I have favorable with amendment. So why don't we just go ahead and start with you, and then we'll go to There we are. Mr. Jocelyn online is also favorable. Then we'll move to favorable with amendment.
Great.
Whenever you're ready. Thank you, and welcome back to Judiciary.
Thank you. Thank you, Chair Bartlett, Vice Chair Davis, honorable members of Judiciary. Great to be back. Delegate Pippi testifying in support of HB 126. So I'm just going to blast through this. So in 1966, Maryland installed a 7-day waiting period for firearm purchases. In 1993, federal law under the Brady Handgun Violence Prevention Act mandated a waiting period to allow for background checks to occur. In 1998, the 5-day waiting period was replaced with an instant check system. During this time, many states reduced their waiting period while Maryland kept the 7-day waiting period. What this bill does, this bill establishes an exemption for the sale, rental, or transfer of a regulated firearm from the 7-day required period after an application is executed when the purchaser, renter, or receiver of the regulated firearm is a law enforcement officer, an individual who retired as a law enforcement officer and in good standing from law enforcement agency, or an individual whom a permit to wear, carry, and transport a firearm has been issued. The purpose of the bill is not to remove any imposed background checks, such as the FBI National Instant Criminal Background Check System, which is NICS, but rather shorten the waiting period, keeping in standards with the times of today, as background checks no longer take 7 days to complete. When a buyer is flagged, additional investigation will continue. Currently in Maryland, citizens permitted or not can go into a sporting goods store and buy high-powered rifles and walk out the same day, but they cannot do this with a handgun without having to wait 7 days. This bill would allow all those who are legally able to own a handgun to be exempt from the 7-day waiting period as they would be with any other firearm. So in other words, there's a little bit of a redundancy here because the individuals that this bill would exempt, which is law enforcement, ex-law enforcement, or individuals who have been issued a carry permit, have already been through all these checks. Effect of the bill. This bill does not strike down any federal background checks, protective orders, et cetera, in any form. It has a very little fiscal impact, if at all. Currently, 37 states do not have a form of a waiting period for firearm to purchase. In 2024, the 7-day waiting period in New Mexico was found unconstitutional by the 10th Circuit Court of Appeals. Rhode Island is 7 days, Florida 3 days, do not require a wait period. So what we're trying to do is just for the individuals that are essentially already allowed to purchase one of these regulated firearms, we're just getting rid of the 7-day redundancy because, again, with the instant check, the fact that they've already been through all the systems, it's just an unnecessary redundancy. So for those reasons, Madam Chair, I ask this committee for a favorable.
Thank you. Mr. Jocelyn?
Good afternoon, Madam Chair. John Jocelyn speaking for 2A Maryland in support of House Bill 126. When the 7-day waiting period was instituted in 1966, the forms were submitted on hard copy paper to the state police by U.S. mail. The state police would process them and then return them again by U.S. mail, hence the need for the 7 days. In the electronic world we have today, that's no longer necessary. Carry permit holders are among the most law-abiding citizens in the United States. They have been trained, they've been background checked, fingerprinted, photographed. There's no reason to enforce a 7-day waiting period because reducing it to 2-3 days it'll probably take to process will not compromise public safety in any way. We think it's in everyone's best interest for us to bring us into this century and to issue this waiver for the persons mentioned in the text of the bill. We ask for a favorable report. Thank you.
Thank you. Members of the House, members of the committee, do you have any questions? Delegate Conaway.
Chair, thank you, Delegate, for coming in with this bill. When a person has a order to surrender their firearms, is that order posted in the system before they surrender, before they actually surrender, before they get notified that they have to surrender their firearms?
So I see, if I can defer to Mr. Jocelyn. Would you like to take that, sir?
Yes, sir. Thank you. Yes, as a matter of fact, the state police licensing people will probably know about it before the respondent does.
And, but what I'm trying to get to is, let's say if you, at 9 o'clock this morning, you're required to surrender your firearm. At 10 o'clock this morning, could you go in and purchase another firearm without it coming up in the, what's it called, the NICS system maybe?
The state police would already know that you'd received that order. That goes to them automatically by electronic means. So they would be aware of the order before you even knew you had one. But no, it would not circumvent that. You would still be prohibited from purchasing the firearm.
So you would come up prohibited when you would go in an hour
Because of
later
the
or
protective
something?
order, yes.
Yes, okay, thank you so very much.
You're welcome.
The Vice Chair?
So, 7 days from the purchase of your initial handgun, because there is a 30-day waiting period for your second or your third, or you can only buy one every 30 days. Is that correct?
That is correct unless you are a designated collector.
Okay. So the 7-day waiting period is only for the first handgun? Is that true?
The current law, the 7-day waiting period is for any purchase.
You understand what I'm trying to get at? That you can only buy every 30 days, a handgun every 30 days. So that's in essence a 30-day waiting period.
Yes and no. I think I understand where you're headed with this.
Thank you.
Let's say middle of this month, you purchase a firearm.
Okay.
If you are not designated as a collector with the Maryland State Police Licensing Division, you would not be able to take possession of another handgun until after 30 days have expired. You could make the purchase, but you couldn't take possession.
Okay. Thank you.
Delegate Taylor?
Thank you, Madam Chair, and thank you, Delegate Pippi, for being here. How does the store or the place where we're buying or selling or renting, how do they know that this person is a former police officer, et cetera, et cetera? Is there some sort of credential, or is there some database that they go to look them up? How do they verify?
Sure, and hopefully you don't see me as copping out here. I'm going to let the expert,
Okay.
Mr. Jocelyn, sir, if you don't mind, I give you permission to answer that.
Law enforcement officers will receive a credential that indicates that they did in fact retire from their agency in good standing.
Got it. Okay, so you have to have this credential with you in order to have this transaction done.
That is correct.
And we're only giving the waiver, so to speak, or the exemption to those that have these credentials, right?
Also correct.
Okay, and then, so the problem that we're trying to solve is, I guess it's not really a problem, it's just these folks don't want to wait, right?
Well, no one, of course, no one wants to wait. I mean, it's part of us as we are as a species. But we're trying to work our way around a requirement that dates back 60 years when we were waiting for the U.S. mail. Right now, the state police, they don't have to wait 2-3 days for the mail to arrive, and then they would process it. Back then, they did it through paper searches. Today, they can jump onto the computer and search 17 databases faster than we can do testimony.
Got it. So it's not up to 7 days. You actually have to wait 7 days.
Yes, that is
regardless.
correct. You
To
might be
whether the
approved in
verification
3,
is
but
there or
you're
not,
waiting
you have to wait.
another 7 business days for you to finally be able to take possession.
Thank you.
Delegate Moreno?
Yeah, this might be a opinion response from you, but is there ever a need that someone would need it faster, or is it more of, as you said, like as a species, somebody purchases something, they kind of just want it sooner than later, but are there any other reasons that you can think of?
I would say logic. Why wait just for the sake of waiting?
Okay, sounds good, thank you.
You're welcome, thank you.
Okay, that concludes our favorable testimony, and now we're going to move to favorable with amendment. Mr. Panek, Mark Panek?
Can we stay or just?
You can stay.
Okay.
Sure.
Stay. Yeah.
Because,
I don't mind.
okay. I remembered this time, Mr. Panek.
Thank you, Madam Chair. Madam Chair, Mark Pennick, President of Maryland Show Issue. I'm an attorney. I would like to bring to the committee's attention a provision of federal law, which is codified in 18 U.S.C. Section 922T, which allows a person who holds a carry permit that has been fully investigated and determined by state officials to be a lawful owner of firearms to bypass completely the NICS background check. That's right in current federal law. So that rationale applies equally to the 7-day waiting period imposed by Maryland. So on my list of things to do when I go to court will be to challenge the 7-day waiting period as irrational because it does not reasonably permit the immediate possession of a firearm. As Mr. Delegate Pepe just noticed that the 7-day waiting period imposed by New Mexico, which is functionally identical to Maryland's, was simply struck down by Ortega versus Grisham, a 10th Circuit decision. So there's no rationale for holding back for a permit that has already cleared a background check. So it's irrationally double over. So I would like to urge the committee to basically follow the federal government's lead because everyone agrees that permit holders of all people are the most law-abiding people of the face of the planet. They have been background checked to the nth degree. They have been fingerprinted. They have been photographed. They have to go through this procedure all the time. They are the most violent, avoidant people that you would ever encounter in your life. This is an unnecessary and bureaucratic requirement that simply should not be continued to be applied. And Congress itself has recognized that. So I would urge an amendment to this bill, if there one to be had, is that it would be actually to follow the federal government's lead on this. I'd be happy to take questions. Oh, by the way, the citations are in my written testimony if you'd like to see them.
Sure, the Vice Chair.
Thank you. I'm reading the exceptions that you have. 1, a law enforcement officer. 2, an individual who has retired from law enforcement. And 3, an individual to whom a permit to wear, carry, or transport has been issued. Is that redundant? Isn't the law enforcement officer a person who has a wear and carry and an individual retired has a wear and carry also?
No.
Okay, could you explain that?
Active duty are covered by federal law, 18 U.S.C. Section 926B. Retired federal law enforcement under LEOSA is covered by Section 926C. And they are authorized under federal preemption law to carry without regard to state law if they retain their credentials and satisfy the requirements otherwise imposed by those two statutes. They don't need permits at all. So many do get permits, especially retired officers, as a way of being doubly safe because carrying firearms for these individuals are kind of a way of life. So they are basically being very, very careful. Now, the third category is, of course, wear and carry permits issued by the Maryland State Police. So those individuals are equally law-abiding between those three.
No. Thank you.
Seeing no further questions, that ends our testimony for House Bill 126.
Thank you very much.
Thank you.
Very much.
We're going to move on to House Bill 375. Delegate Stinnett. Delegate Stinnett, do you have a panel?
Yes, yes, and they're all coming up.
Okay. Okay, so if everybody could just identify themselves so I can check you off on this list.
Jennifer Johnson.
John Morris.
Sandra Johnson. Sharon Duncan Jones Eversley.
Okay, great. Thank you very much. Delia, whenever you're ready.
Okay, thank you. Good afternoon, Madam Chair, Madam Vice Chair, and fellow members of the Judiciary Committee. I am Delegate Sean A. Stinnett, and it gives me great honor to stand before you today as the lead sponsor for HB 375, Granny's Law, Estates and Trusts, Interpretation of Wills, Evidence of Intent. This is my very first piece of legislation, and I'm asking for a favorable report. Granny lived for over 60 years in the 41st Legislative District in Baltimore City, right by the Forest Park Golf Course. District 41 is a district I proudly lived my entire life, and now I have the pleasure in serving as delegate. My colleagues of the 41st District support this legislation, and we hope you do the same. This legislation will take a tragedy and give Granny her life story the victory it is so deserving of. This legislation would take things that have not functioned properly for years in our state's probate system and put them in proper working order. This legislation is imperative. Justice for many is straightforward and makes total common sense. This legislation is gaining support from people in other states, and once passed here in Maryland, will easily open the gateway for other states to follow. While it is unknown exactly how many Maryland residents go through probate annually, we on an annual basis lose approximately 61,000 Maryland citizens a death. Hence, we can estimate, based on the death total alone, that thousands of Marylanders can benefit from the Granny's Law. This legislation will help correct historical wrongs and reinforce what we as members of the Maryland General Assembly already see as a priority. This legislation will honor Granny, a woman born and raised right here in Annapolis and who helped integrate the United States Naval Academy. With that said, I ask for a favorable report and will partake with any questions the committee may have.
Thank you, Delegate. And who is next?
That would be me.
Okay.
Good morning, Chair Bartlett, Vice Chair Davis, and committee members. 2 Timothy 1:7, for God has not given us a spirit of fear, but of power and of love and a sound mind. I sit before you today knowing that all I have walked through, no one in our state ever needs to go through again. The terrible details are written in my written testimony for your review. I ask you to vote yes for Granny's Law, as it is good, solid, simplified legislation that corrects historical wrongs in the probate system and supports the work of your fellow Maryland General Assembly colleagues on the Public Health and Minority Health Disparities Subcommittee, which has existed for the last 23 years. I am grateful for everyone testifying here today, to Delegate Sinnett for leading this legislation in the House, for John Morris, who is sitting to my left, for writing the legislation and for being a cancer survivor, for my best friend Kim, who sadly lost her battle with cancer, and for a young man who will testify before you, Amir Coates, whose mother, another very close friend, tragically passed from cancer. I would be remiss if I did not give a special thank you to Dr. Jonathan Farley, who traveled from upstate New York, in loving memory of his mother, Dr. Ina Farley. And I thank you all for my House co-sponsors, for many of who are in this room right now, for supporting this legislation. Vote yes for Granny's Law and positively impact multiple generations throughout our state. Vote for Granny's Law and help restore dignity and honor where currently only tragedy exists. Vote yes for Granny's Law and honor my grandmother, a woman who was born and raised right here in Annapolis and who helped integrate the United States Naval Academy. The motto for this legislation is, I meant what I signed.
Good afternoon, Mr. Chairman and the other members, honorable members of the committee. I am John Morris, and I urge your support of Granny's Law, HB 375. Some time ago, the General Assembly affirmed the elimination of racial health disparities as a matter of public policy. This bill addresses an unintended consequence of that affirmation, where decedents may not unreasonably rely upon this affirmation of public policy as informing a bequest to a health provider, so that they could fairly assume that the state, having made an affirmation of public policy, would apply their bequest without their having to make any further qualification or restriction. In this instance, Granny made such a bequest. What this legislation would do would allow for her intention to be affirmed to the court to resolve any ambiguity of what the decedent intended, given that affirmation of public policy by allowing and empowering the personal representative to offer evidence of the decedent's life story as evidence of an intention to promote the public policy that this body has affirmed. For that reason, to the extent that it promotes and advances the intention of the decedent while affirming the public policy that this body has affirmed, I ask that a favorable report be given for this legislation.
Thank you. And whoever is next.
My name is Sandra Johnson. I'm Jennifer Johnson's mother. I'm testifying in support of House Bill 375, Granny's Law, and asking for your favorable support. I've lost my husband, Jennifer's beloved father, to a heart attack several years ago. I've also lost many friends and relatives to Alzheimer's, cancer, and cardiovascular disease. In addition, I spent more than 20 years, as did Jennifer's grandmother, working for the state of Maryland juvenile justice system. And so I've seen many of the mental illness problems affecting the African-American community. Jennifer was an excellent caregiver for her grandmother, attending to all of her needs. I'm very proud of her for the tender, loving care that she showed her grandmother, especially as she grew older. However, I was not pleased with how the court system handled my daughter, and I've done everything in my power to quickly get her out of a situation that should not have happened. Her lawyer asked me to search every source possible to locate any and all financial information. As the mother of Jennifer, who was incarcerated per Judge Juliet Fisher's orders in September 2022, while Jennifer's friend was dying of cancer, I spent several days searching my daughter's home, trying to piece together information to satisfy the judge's court order. In my search for the required information, I followed the court order and tried to find any and all information. I prayed that the court would have mercy on my daughter and release her from confinement. This ordeal was beyond disturbing and inflicted unnecessary chaos and upheaval in all of our lives. I ask for your committee's full support for this legislation to help bring justice to our family and to prevent anything like this from happening to other families in Maryland.
Thank you.
Good afternoon, Madam Chairs and the Honorable Judiciary Committee. I am Sharon Duncan Jones Eversley, a lifelong Marylander, a professor emeritus, a social epidemiologist with over 40 years of experience in public health and human services. I support Granny's Law. It is smart and it is timely. The fundamental justice question posed is simple. When an elder makes a clear, cognitive, and intentional decision about their will, why should that decision be ignored, altered, or reinterpreted? Let's consider the estimated $120 trillion of transfer of intergenerational wealth happening right now in our country. For Marylanders from the silent generation, the baby boomers, they worked hard to save their money, to earn their pensions, and to purchase property and homes. The transfer of wealth will have intergenerational impact on their families, their beneficiaries, and the state. Yet some elders' final wishes are second-guessed in probate court, not because of fraud or incapacity, but because of subjective interpretation and excessive judicial discretion. When elders' legal expressed intentions are dismissed, their grieving families are unjustly denied financial stability and closure. Granny's Law does not weaken the court, it strengthens it. This bill gives structure when there has been partiality and clarity where there has been confusion. It ensures the credibility of credible evidence of the elder's intent is respected and not denied. Granny's Law fortifies Maryland's commitment to not only be an aging, longevity-ready state, but an aging longevity justice state. Please honor not just her, but all Marylanders' intent for their intergenerational wealth being transferred to their designated and their predetermined beneficiaries. Thank you for being gatekeepers of justice, and I hope and pray that you please successfully pass this bill. Thank you.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you very much, Delegate Stinnett, for bringing the bill. And a very esteemed and very impassioned panel. So thank you for your testimony, all of you. So I'm going to two scenarios. I'm not sure who you want to answer the questions, whether it's you or somebody else. But one, if there's a will that's already been done, and the will bequeaths the money or the assets to somebody in the family, but the personal representative believes that there's clear evidence that the money should go somewhere else. What happens there? And then scenario number two, if there is no will, and Maryland law is pretty well established now that there's a way the money is, or the assets, all the assets are transferred to essentially to family members. But the personal representative, so in that scenario, I'm asking, is there some sort of litigation as to whether the personal representative's beliefs that the money goes somewhere else versus to the family? And how does that operate?
So I can take that question. The piece that you're not aware of is that there is language in most people's wills that specifically states, as the personal representative, they do not sit under the adjudication, order, or direction of the courts. Another piece of very common language that is in most people's wills is that they can do any and all things on behalf of the decedent, just as fully as if they were alive. But what has traditionally happened, unfortunately, in our state is that judges have said that does not mean what it means, ignore it, and you follow my directions instead. And while that may be good intentions, the road to hell is paved with good intentions.
Okay. All right.
You will hear from a person in the next panel that will address your intestate question that had some very harmful intentions that happened to her family, which should never have happened.
Okay, so let's go back to the with a will test date.
Mm-hmm.
If the will specifically says that the personal representative gets to decide how the money should be distributed, you want to make sure that the court abides by that. Is that essentially, that's essentially what you're saying?
Yes.
Okay, that's it. Thank you.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate panel, for coming in to testify. What exactly was Granny's request?
That the money be used that was going to the American Cancer Society, the American Heart Association, the Alzheimer's Association, and the Alliance for the Mentally Ill, that it be used to benefit African Americans. The charities refused, and instead, when my best friend was dying of cancer, threw me in jail, and I could not get out until I gave them over all of my grandmother's information. My grandmother would never, ever, ever have wanted that.
Was this, if I recall correctly, was this involving, say, $100,000 or something?
It was a considerable amount of money, but it doesn't matter whether it was $5 or not. It should never have happened.
Okay, so you're saying that they didn't turn the money over to the Cancer Society for...
The charities refused to use it to support existing Maryland state policy, which is to work towards eradicating health disparities. African Americans are the predominant group of people that have health disparities. They refuse to use it for that purpose.
And how was the subjective interpretation, how did that change what the will stated?
My grandmother wanted me as her personal representative.
Yes.
Instead of listening to me instead of following Maryland State existing policy that is supported by a subcommittee in the Maryland General Assembly, they refuse to do that. Although all of these charities have documented many, many times that there is a disproportionate need for African Americans to have supportive funding, they refuse to use the money for those purposes.
Okay, thank you.
Delegate McComas?
I realize this is a very complicated issue, but I was wondering, is there any litigation that we could look at that won't be volumes of paperwork, so we can get a better grasp of, because what I'm wondering is, because it was singling one particular group, okay, of folks, and you're correct about your analysis of the care for African Americans versus other folks. Do you think that they felt that that would be discriminatory and that they couldn't do it as I guess a 501c3 or whatever they are?
No, they have existing programming already specifically targeted towards African Americans. They didn't want to do it. And instead, they thought that it was better to remove me, the voice of my grandmother, ignore her will, and throw me in jail, or I could not get out until I gave over all of her information. They also ignored 8 subject matter experts in all of these disease state areas. So this was intentional. Why they did it, one could question. But yes, there are court transcripts and stuff. But the bottom line is, if they had never forced ignorance of the will, this would not have happened.
Correct.
And it's not an isolated issue. It is a very common issue where people's last will and testaments are being ignored.
And is this Baltimore City states I guess, what do I want to call it, probate or register of wills?
No, it was Baltimore County.
And can you give me like I guess, Delegate, can you just give me so I can kind of look up at least the.
Sure, I'll provide
Okay,
that.
great. No, I just kind of want to understand it because it's like, what?
Exactly how it sounds is exactly what it is. It's very backwards, and it's very wrong.
Well, my question to you was there ever an investigation by some outside agency that could review this and say, wait a minute, this isn't right?
No. If I had not come before you, and if John Morris had not stepped up to the plate to help write this legislation, probably no one would have known about it, and I would have just been crying and depressed, and no help would have come. But this legislation changes that for everyone and ensures that it does not happen to anyone else in our state.
And I also want to direct the committee to the literature review. My references with my written testimony. Even University of Maryland law school has been looking at issues of inconsistencies regarding the misinterpretation or excessive judicial discretion. But there are several articles starting back from 2019 all the way to 2026. This is not just unique, but just the fact that our University of Maryland Law School is also looking at these issues, also looking at historical patterns, and the fact that there isn't any structure. It's kind of almost as if we're talking about a paternalistic autonomy as opposed to honoring the self-determination of someone who's cognitive. I can see if there were any neurological challenges that you can question about incapacity or fraud. That isn't the case. And so I think that when we're looking at the literature, particularly a lot of the law journals, this is an issue that has been targeted across the country to people of color and to females. And we're talking about individuals that are blue-collar workers, where their transfer of wealth they worked hard for. And we're also talking about middle-class individuals who may not be elite. And so we have these subjective classisms, right, that we can, and these biases, and I don't want to make the assumption that someone would knowingly do it, but they could knowingly or unknowingly do it and change it. Why would you want it to go to African Americans? If the person wants that, their representative is able to give that validation in reference to health disparities, why should that be overturned if the person is cognitive and very clear? So I do encourage you all to read many of the articles. There is a live link on every one of the citations that I did provide in my written testimony.
Thank you.
I would just like to add, because we have stated it is a nationwide issue. I would like
That's actually my question for Delegate Stinnett.
Okay.
What are the other states?
I believe, is it New York?
We're working with grassroots efforts in New York right now to get this legislation, once it's passed here in Maryland.
Okay, but I thought in your testimony, Delegate, you said there were many states, or there were other states.
There are other states, but I know the primary state is New York.
Okay, so has anyone passed this legislation thus far that you know of?
No.
Okay,
No,
that's fine.
they're looking at us to see if we can be that foundational stepping point as far as to be able to pass in other states.
Okay.
And Texas does have something similar, but it does not have a equity component with it. But I just would like to add that U.S. Congressman Burgess Owens has backed this legislation. D4 Women in Action has backed this legislation. And the Positive Women, Black Women for Positive Change has also backed this legislation, as has the the Maryland Commission on African American History and Culture. So this is very well supported, and it is definitely a need. It is not an isolated situation. It's a systemic problem that has roots all throughout our country.
Thank you. Delegate Taylor?
Thank you, Madam Chair. I would love to read the information that you said you have in your testimony, but I don't recall your names. Can you just?
Sure, it's Sharon Duncan Jones Eversley.
Thank you very much.
Delegate Conaway for second bite.
To the witness, to the delegates left, were you put in jail in reference to this particular issue?
Yes, and I've never been in trouble with the law a day in my life.
And you were charged with what?
Nothing.
So they just put you in jail for no reason?
Correct.
And were you able to sue or anything like that?
No.
Okay, thank you.
Thank you. That concludes this panel. We're going to move on to our next panel, also favorable, Jonathan Farley, Amir Coates, Davina Fisher. So I'm assuming you're Jonathan Farley.
Yes.
And Davina Fisher? Okay,
Good
and
day.
Amir Coates. Is Amir Coates here? Okay. All righty, so whoever, Mr. Farley, you want to start?
Yes, on February 5, 2023, my brother Christopher John Farley directed police who dragged my 84-year-old mother out of her house, tying up her hands and feet, screaming, "You're breaking my arm." She hadn't been declared mentally incompetent by a judge or a doctor. She was the sole owner of her home. You can see this for yourself on the YouTube channel Free Ina Farley that's gotten over 2 million views. Before she passed away, she told a church friend on video that she wanted me to have her house and all of her physical possessions. She could not change her will because she had been locked up at that point against her will in a memory care facility and not allowed to make phone calls or consult a lawyer of her own choosing. After my mother passed away, my brother, through his agents, used the threat of physical force against a 79-year-old Black woman, Jane Farley, then living in the house and here today, to illegally evict her and seize the house. And now my brother claims to have sold it, keeping 100% of the proceeds, according to his lawyer. So I hope my former Harvard University classmate, Senator Malcolm Augustine, and his colleagues here will support HB 375, Granny's Law. I support Granny's Law because violating the wishes of the elderly concerning what they want to do with their assets is another form of elder abuse.
Thank you. Amir, are you ready?
Yes.
Would you like to go ahead and tell us what you have to say today?
Good afternoon. My name is Amir Coates, and I'm 9 years old. I lost my mom, Patrice Langford, unexpectedly on May 22nd, 2024, and my life will never be the same. My mom worked as a manager with Care First, Blue Cross and Blue Shield, and was friends with my Aunt Jennifer for almost 30 years. I am super grateful for my grandma, granddad, Aunt Cheryl, Aunt Jennifer, Miss Sandy, Dr. Fuchs, and all my teachers, mentors, my village. I will always miss my mom. She passed away from colon cancer. My life is forever changed. Don't think because I am a child, I don't see what's going on in this country. I do, and my friends do. This mess affects us all. It is your job as grown-ups to make things better for children like me. So do your jobs, make things better, correct the mess so when I grow up, things are better, not worse. I didn't know because they tried to keep it away from me how horrible the courts treated my Aunt Jennifer and all she walked through. It was wrong. I remember being little and being with my mom and visiting Aunt Jennifer's granny. I also have vivid memories of visiting my Aunt Elsie with my mom. Aunt Elsie lives to be 100. Hurting elders is wrong. Intentional hurting people is wrong. Now I urge you to do the right thing and honor my mom and Aunt Jennifer's granny and everyone else loved ones who have passed on to glory. And everyone else loved ones who have passed on to glory and passed House Bill 375, Granny's Law. Isaiah 11 verse 6 says, and the little child shall lead them. Thank you.
Amir, I'm very proud of you, and I'm sure your mother would be very proud of you.
Yes.
Thank you for coming down here today.
Did amazing. Thank you. Good day, y'all. Not at all. Won't try. Good day, y'all. And Chair Bartlett, Vice Chair, members of the committee. Whew, that was heavy. My name is Divina Fisher, and I'm a victim's advocate with over 20 years of experience, and I'm here in support of House Bill 0375, Granny's Law. For more than 3.5 years, I was my mother's full-time unpaid caregiver while she battled terminal stage 4 cancer. I left my job and my career to care for her, managing her medical needs, household affairs, and finances. This was an act of love, responsibility, and commitment. When my mother passed away intestate, I was lawfully appointed as personal representative of the estate alongside with my brother. We chose it that way. Despite this, a probate judge removed both personal representatives without notice, without contacting us, and without evidentiary hearing, based solely on an unverified claim that I was out of the country. That claim was false. I had been in Florida for 1 week and was fully available to appear. At the time of the court acted, the estate had already been open for nearly a year and no emergency existed. When I returned, I attempted to continue paying the mortgage only to learn I could no longer access the account because the authority had already been transferred. That single decision triggered irreversible and costly consequences. My brother and I requested mediation in good faith. The court declined and instead ordered the forced sale of my family's home. The estate lost all tangible personal property and the home ultimately foreclosed, and everything my parents worked hard for was lost. Outcomes that were entirely preventable and irreversible. House Bill 0375 is necessary because it restores balance to the probate process by allowing courts to consider evidence of intent, protecting lawful personal representatives, and recognizing the essential role of caregivers, especially when a person dies intestate. Probate courts should not exist to honor intent, protect families, and ensure fairness, not silence caregivers and reward misrepresentation, or issue irreversible harm or costly decisions. This is in honor of both of my parents for generations to come.
Thank you. You're welcome. Thank you all for coming and testifying today. I do not see that there are any questions for this panel. Thank you so much for coming down. We have in opposition, Laura Thomas. And whenever you're ready, Ms. Thomas.
Thank you. Madam Chair, members of the committee, my name is Laura Thomas, and I'm the chair of the Maryland State Bar Association Estate and Trust Section. And I'm here today in opposition to this bill. And the primary reason we as the Estate and Trust section, stand in opposition to the bill is that under Maryland law, we have a simple solution to this issue, and that is that the person who is writing a will or having their will written for them by a lawyer can include language in their will to restrict a charitable bequest for a specific purpose. And in those instances, the charity has to honor the wishes of the testator, which are expressed in the will, and only use that money for the stated purpose that is contained in the will. In addition, the bill upends established law regarding the interpretation of wills and the ability of the court to ascertain the exact intent of the testator, the person who wrote it, after they are deceased and no longer there to testify or give their language of their wishes. The best evidence that the court has is the will that's in front of them, and that's what they use to determine the intent. Last, I can say that as chair of the Estate and Trust section, having now testified on this bill for 2 years in a row, have also taken it upon myself to make sure that I'm reminding members of the Estate and Trust Law section that we need, as attorneys, to make sure we're asking our clients these questions, that we are making sure that when somebody does leave a bequest to the charity, we are asking them, do you want to leave it to them for a specific purpose? And going beyond that surface level, this is what the client said they wanted question, to use our knowledge and our expertise to go beyond and make sure that the true intent of the testator is reflected in the will. Thank you.
Thank you. The Vice Chair?
Thank you, Madam Chair. The initial arbiter of the intention of a will is left with the Orphans Court. Is that correct? Orphans Court judges.
If there is a question about the plain language of the will, yes, the Orphans Court is the body who determines what the testator's intent was.
Okay. Across the state, are those judges lawyers?
No.
Is there a minimal qualification for an Orphans Court judge?
You must be 18 and I believe live in the county where you are running to be elected.
Okay, thank you.
Delegate Taylor?
Madam Chair, so just in this case, the will that was left behind, and correct me if I'm wrong, asked that the assets go to a charity. What you're saying is it didn't further define what the charity should use the monies or the assets for. Is that what you're?
I have not in a while looked at the will for this case. I know that it specifically said that assets were to go to charity, but there was not a statement that said it was to be used to reduce health disparities.
Now, if the personal representative who has been given authority over the, I guess, the intent of the will, says, the assets will go to, I think in this case it was the American Cancer Society. And the American Cancer Society has a program that I, as personal representative, am aware of. And I say, or I ask, or I make the request that the assets be used for this program. Are you saying that I have to spell all of that out in my will? Or can the personal representative direct those funds or the assets to that particular program?
So in order for it to be binding on the charity, it must be stated in the will, because the personal representative's job is to fulfill the testator's intent as expressed in the will.
Thank you.
Delegate Cardin?
Madam Chair, thank you very much for being here. Some quick questions. First of all, can an Orphans Court judge, first of all, there are a few jurisdictions where orphans court judges are required to be attorneys. Isn't that correct?
That is correct.
Okay, like Baltimore County is one of them.
Yes.
Okay. Can the Orphans Court investigate intent if there's questions that the personal representative brings up? Are they permitted to?
So there are specific reasons why the court can look into information from outside of the will to determine the testator's intent, and that is limited to a latent ambiguity. I think I gave the example in my written testimony. If you leave money to your cousin Mike, but you have two cousins named Mike, the court can use extrinsic evidence, meaning evidence that's not in the will or the plain language of the will, to determine which cousin you intended to leave that money to. Otherwise, the court is not allowed to look at evidence or intent or information from outside the plain language of the will.
And is the MSBA, has the MSBA taken a position on whether there should be additional flexibility for that investigation? Is that something that you guys have ever pondered?
The MSBA as a whole, I do not know.
Or, I mean, your section.
Oh, our section, the issue becomes, number one, where do we draw the line, and when do we know for sure that it's what the testator wanted?
Right. Is there a chance, I guess, for potential fraud or other ambiguities to be created if you start allowing for investigation, especially if the Orphans Court, as has already been stated by my colleague from Charles County, might not have a tremendous amount of legal experience?
I believe so.
Okay. And then can a Orphans Court judge remove a personal representative without giving them notice? Do you know that?
I do not believe so.
Okay. And if it's intestate, does a personal representative have more flexibility to be able to tell a charity how to use money?
So if you have an intestate estate, the Maryland statute dictates where your probate assets go. So typically it's your closest blood relatives. And there wouldn't be a charity involved in that situation, because outside of once you get through all of your blood relatives, it goes to the state.
Thank you. Thank you very much for clarifying all that.
Thank you, Madam Chair. Thank you. This gets really kind of specific on us. This whole bill focuses on a really specific scenario. In your practice, though, I want to ask you a question about practicality. And I'll use this scenario. I sit on the board of a university, and there may be a bequeath to the university. And the personal representative will come in, no courts generally involved under normal circumstances, and the personal representative will say, it is the deceased would like for this $100,000 to be used for students who derive from the Baltimore metropolitan area. And as the charity receiving this, we generally acquiesce. Now, the will may say, just give the money to the university, but we acquiesce to what the PR has asked for. In your practice, is that the normal way things happen?
I have not come across that in my own practice. You can always request that the charity do something specific with the money. That's great that your university does typically follow, honor that if it's not in the will. But I have not come across that in my own practice where I would be able to say, yes, that's a general.
And so I will tell you, I sit on a number of boards, and those bequeaths come, and we honor whatever the PR says. I see this as a really unusual set of circumstances, and I don't know exactly how we got here or why, but I just see this as very unusual.
Delegate Taylor.
Thank you, Madam Chair, for the second bite of the apple. I just want to, like Delegate Phillips has a story, so do I. I am the personal representative for a friend who I went to high school with. And we went to Duke Ellington School of the Arts. And he's a painter, right? And he made me his personal representative. He passed away. I know his wishes. And he made me personal representative, and I'm not his family member. I'm his classmate. And I understand why he made me personal representative, because he knew I would make a decision about where some of his assets would go that would help our school, right? And so I'm not sure that, like, I'm looking at, I think this is your testimony where it says, the scope of this bill is so narrow, it's not likely to reduce health disparities in Maryland, the intended purpose of the bill. I feel like that's a little disingenuous. This is not, the intended purpose of this bill is not to reduce health disparities. It is to make sure that the will of the person that passed away is acknowledged and adhered to. So, you know, I think what is your comment on that, I guess, is the question.
The bill is specifically limited to situations where a bequest is left to a health provider, health charity, I believe. So it does not address broader, any other bequest that's left under a will.
So if I were to say, if we were to give the monies to, or the assets to Duke Ellington School of the Arts, but I wanted it to go to the theater program, but they gave it to the music program, is that what you're saying, that the school, the foundation has its
discretion,
supersedes or has its own discretion as to where it should go? And my wishes, which are the wishes of my classmate who's passed away. Okay, but this law, if we were to pass this, would change that?
Not in your case, no. Because it's specifically limited to health bequests.
Thank you.
You're welcome.
Thank you. Seeing no further questions, that concludes the testimony for House Bill 375. Delegate Cardin, is it good time? Okay. House Bill 17. Delegate Cardin.
Good afternoon, members of the committee, Madam Chair. For the record, John Cardin on behalf of House Bill 17, and asking you to give it a favorable report. I believe this is going to go to the brand new and improved Estates and Trust Subcommittee. I'll try and explain as best I can, but I have my witness here, and hopefully this will go pretty quickly. And then if you all want to ask legal advice afterwards.
Is that Ms. Burrows? Ms.
Yes.
Burrows? Okay, thank you.
Thank you. When non-Maryland decedents, people not from our state, die and they're domiciled outside of the United States, so they're foreigners, owning intangible property like a bank account or a brokerage account or some sort of money asset here in the state, there's no clear probate venue that exists in Maryland which would enable the personal representative to open an estate here and obtain letters of administration for this intangible asset. Banks and other financial institutions typically require these very, very specific documents, and if we can't get them to them, then they're gonna have to wind up opening up the estate somewhere else where they can get the documents. And we do not want to scare people away from the state of Maryland. We want to open up estates here. We want to keep our people here. We want to spend money, time, and use the assets of our great state of Maryland. So this disconnect leaves the fiduciaries and beneficiaries of the decedent, these individuals often residing here in Maryland and seeking professional representation here in Maryland with Maryland-based estates and trust practitioners and Maryland state businesses without a legal mechanism to obtain control over these assets, and therefore they do it somewhere else. That's the problem. Apparently the solution is this bill. And I still have a minute, so I normally would say I'm just gonna let it go there. But I'll also mention another piece of, and by the way, you have this in the written testimony of the MSBA, but even if a personal representative is successful in advocating that the county register of wills opens the estate of a non-Maryland decedent here in Maryland, because of the different rules and the different ways that the different jurisdictions work, they could require different things, require different documents, not be able to talk to each other, and therefore there's lots of confusion and it makes it cost more and be more reasonable to do it somewhere else. For that reason, we have this bill, and I will submit, Madam Chair.
Thank you. Yes.
Good afternoon, Madam Chair, Vice Chair, and the committee members. My name is Leanne Broyles. I am an estates and trust practitioner, and I'm testifying today on behalf of the Maryland State Bar Association Estate and Trust Section. And I am urging a favorable report on this bill as amended. And I think you have been provided with an amendment on the bill. And this is an amendment that the Estate and Trust Section and the Register of Wills for the state came to agreement on together as an improvement over the bill that was initially submitted. So as Delegate Cardin stated, this bill is an important step in modernizing Maryland's probate venue rules. As our society becomes more and more global, practitioners are seeing an increase in cross-border estate and trust issues in general. Notably, the financial institutions in the United States generally require a United States issued letter of administration in order to release financial assets to a deceased person's assets. The letters of administration are the documents that are issued by the Register of Wills that has jurisdiction over an estate. And traditionally, venue exists based on the domicile of an individual and the situs of his or her property. And so traditionally, where an estate can be opened is tied specifically to that. And again, our existing law is unclear regarding the ability to open an estate in a Maryland county where there is no property that is physically sitused. And again, at the same time, it's more and more common that we have individuals who die living overseas and they have bank accounts located here. This presents serious logistical and financial issues for families, personal representatives, and attorneys. So the bill aims at simplifying the opening of an estate in these circumstances, and it also clarifies that when an estate is open in these circumstances, no real or tangible property here or domicile of a decedent, that the inheritance tax doesn't apply. And again, that's an issue where we're seeing inconsistent application among the registers in different counties. So,
thank you.
And do we have, Madam Chair, I'm sorry. Situs, for all of you lawyers and non-lawyers alike, is just simply another word for location.
Thank you.
Okay. No questions. I do. Oh, okay, thank you. I could hear. Delegate Embry, sorry, the subcommittee chair for Estates and Trusts.
Thank you, and thank you. And this bill does make sense to me, except the fiscal note talked about it the impact on the income tax exemption. And I don't know if you saw that, and I don't mean to put you on the spot, but in your view, is there any, inheritance tax, I don't know why I said income, inheritance tax. Do you view this bill as impacting the inheritance tax, what's collected, what's exempted?
Only, I would say, insofar as, so first, I think that Register McFarland is going to testify also. Okay. But from what I understand in my experience, this specific issue where you have a non-resident decedent and there are ties to Maryland where an estate needs to be open, I think that the scenario is arising very infrequently. And so it's only in a circumstance when you have one of the registers who is saying, yes, an inheritance tax applies here, which it's an inconsistent application and unclear that the law actually intends that. So I think it would be minimal, very minimal. I don't think it would be a significant impact on the inheritance tax.
Okay, thank you.
Yeah.
Thank you.
We have one virtual person, Dr. Cross, Leanne Broyles, and Byron McFarland. Are the other two here?
I think just Mr. McFarland.
Because I already went.
The doctor's not here either?
Adopt.
Thank you. Mr. McFarland, you can go for it.
Yes, good afternoon to Chair Bartlett, Vice Chair Davis. It's nice to see you. My name is Byron McFarland, for the record, Register of Wills for Howard County, and I chair the Maryland Register of Wills Association's Legislative Committee. We're here to support Delegate Cardin's bill with the amendments that we have worked out. I know you all like it when everyone works everything out ahead of time. The cross file was heard yesterday, and so my partners in the bar and I had a colloquy on Monday. We worked out this amendment. We actually think it improves the bill to accomplish precisely what Delegate Cardin and my colleague here have said. I always like trying to remind folks that most of our probate law was written a very long time ago. It was written at a time where the town you grow up in was the town that you lived your whole life in, and you never really moved. We're seeing more and more, particularly in jurisdictions like mine in Howard County. 22% of our population in Howard County is foreign born. So we deal more and more with folks who they may have lived in Maryland for some period of time, they moved abroad, they died abroad, but they've got something left here for a family member to deal with. And let me give you a really quick example. I'm a lifelong Howard Countyan, okay? If I went down the street and opened a bank account at CQ, which is a Maryland-based bank, it's a checking account. I have no joint owner. I have no beneficiary. I put some money in it. I decide to leave America and I relocate abroad, never to return. When I pass away, my estate will be opened in that foreign nation, but my family will have some asset here to do something with. What this bill does is clarify where that estate should be opened. As a lifelong Howard Countyan, someone could figure out, oh, the last place that Byron lived was in Columbia. That's where the estate should be opened. That's what this does. And to your point, I wanted to address your question, Delegate Embry. And I think I tried to convey this to DLS in our agency impact. This will have no impact on inheritance tax revenue. This simply clarifies existing law. And when, again, my colleague said something about disparities in application of these provisions, it's because the law is so old that it's difficult to apply.
All right.
Thank you very much.
Thank you. I have a question. So you're out of the country and you die, but you still have a bank account here. Are we opening two estates?
So there would be an estate opened. There would be an estate opened where I'm domiciled in that foreign nation. So if I died in the United Kingdom, for example, their courts would handle my estate. But that bank account that's here in America, we would need a local court to do something with it. And, it's one thing if we're dealing with, a court in, let's just say Canada or another English-speaking sort of Anglo, centered sort of country. But, an awful lot of the estates that we're dealing with, we're talking about court systems that are not like ours. In Howard County, and we deal with a lot of folks who live in India, South Korea, China. And so we need someone to be able to go, as my colleague said, go to the courthouse, open an estate, get a letter of administration, take it to CQ, and disperse it to the heirs if the person died without a will, or their beneficiaries under their will if they had one.
So in answer to my question, you would open two estates?
Yes.
Okay.
Yes, and I was just going to add that our experience as practitioners is that this accounts at CQ. CQ is not going to accept the Indian letter of administration or the UK letter of administration. They require something that was issued from the US.
And I want to clarify, though, I think that what Mr. McFarland meant was if you're domiciled in a foreign country, it would be two estates opened. But if you were traveling to UK on vacation,
yes,
there wouldn't be an estate opened up. I just want to make sure that was clear for the record.
Thank you.
Okay, great. I don't see any further questions. Do we have Dr. Cross online?
No, we do not.
Okay. Well, that concludes the testimony for House Bill 17. Next, we are going to hear, Delegate Stewart with House Bill 309. Members, I'm skipping, Delegate Boucher is in another hearing. We'll go back to him. So Delegate Stewart, it looks like it's just you, so whenever you're ready.
Cool. Thank you, Madam Chair, members of the committee. Great to see you and the Vice Chair in your new roles. So every day, the state of Maryland sends out countless summons. These are basically commands in the form of a summons. And the summons at the very bottom says, your presence is required by law. But currently, those summons represent something of a broken promise, because when we allow the entrance of a courthouse to become a dragnet for unrelated civil enforcement, we are telling Marylanders that answering the state's call in that summon is at the risk of their liberty. And the data shows, unfortunately, that Marylanders are hearing us. So between 2017 and 2018, the Access to Justice Commission tried to estimate the number of Marylanders who were not coming to the courthouse because they feared civil arrest. And they documented 472 instances, mostly survivors of domestic violence, women mostly, who chose to stay with their abusers rather than seek a protective order because they feared civil arrest at the courthouse. They found another, and this is undercounting, but they found another 110 witnesses to crimes who chose to let criminals go free rather than risk a civil stop in the hallway. So we aren't just arresting individuals when we do this, we are arresting the process of justice itself. Now, you'll see in your packets that one common thing that some of the opposition, not that the opposition is super voluminous, but the few people that had some questions about the bill spoke to the original version of it that basically said that we were going to be prohibiting civil stops within 1,000 feet of the courthouse. So I'm introducing a sponsor amendment that you guys should have in the next day or two that cuts that 1,000-foot buffer zone entirely and specifically focuses on the courthouse itself, because I think the opposition, including the sheriffs, made some good arguments about, okay, well, what if someone commits an act on a bus and they're driving by the courthouse and that was in 1,000 feet? So we're gonna fix that in sort of a surgical sponsor amendment. And that, I think, removes some of the uncertainty for law enforcement. And so that way it's sort of no longer a question of, how do we know where this person is going, or, is this related to the courthouse? And it's really a question of what's our priority. So to be clear, this bill, it doesn't create any sort of lawless zone. If you have a criminal warrant for your arrest, you can still be arrested. If you're a threat to public safety, you still will be detained. And if there is a judicial warrant for your civil arrest, you can still be arrested. This simply says that if there's no judicial warrant, there's not a real warrant signed by a real judge, you cannot be civilly stopped and arrested inside a courthouse. And so essentially the rationale is simple. We can't afford to trade a functioning justice system for civil dragnet offenses. A court without witnesses, Madam Speaker, is just a room. HB 39 ensures that access to justice is a physical reality at the front door of every courthouse in Maryland. And when we command a citizen to appear, we need to make sure that they do so with the full protection of the law. Thank you.
Thank you, Delegate. Before we move to questions, let's complete the favorable panel. Do we have Rena Shaw online?
Yes.
Okay, and Susanna Feldman?
No Susanna Feldman.
Okay. All right. Ms. Shaw, we're ready whenever you are. And good to see you.
Good to see you as well, Chair Bartlett. Thank you so much for the opportunity. Good afternoon, everyone. I'm Rena Shaw. I am the Executive Director of the Maryland Access to Justice Commission. We are here in support of HB 309 and request a favorable report. As our name suggests, we believe that justice must be accessible. For the justice system to function, judicial facilities must be viewed as safe, neutral, and an impartial forum. Marylanders use judicial facilities to protect themselves and their communities from harm and to exercise fundamental rights. A courthouse is a judicial facility that has a unique constitutional responsibility to protect due process and access to justice on behalf of the entire public. That mission is jeopardized when victims, witnesses, and litigants are afraid to come to the courthouse to file and defend against cases or serve as witnesses in ongoing cases because they fear going to a courthouse or another judicial facilities. Other judicial facilities are where vital determinations regarding unemployment, benefits, zoning, workers' compensation, and other professional licensing can occur. Further, modern judicial facilities also serve as hubs for essential services, including victim services, self-help centers, housing counseling, and local government services. If these spaces are not deemed safe, neutral, impartial, Marylanders will opt out of justice and stay in harmful situations or use extrajudicial means to resolve disputes. What that means is that a victim of abuse will remain in an abusive situation. A tenant will not file for an escrow to have their heating turned on or mold remediated. A worker will fall behind on supporting their family because they will opt not to fight wage theft or appeal their unemployment decision. For these reasons, we hope that we can keep judicial facilities safe, neutral, and accessible, and support a favorable report on this bill. Thank you so much.
Thank you. So I see Delegate Conaway has a question.
Thank you, Chair. Thank you, Delegate, for bringing the bill. So what can a person be civilly arrested for? What type of charges?
Traffic offenses, housing, sometimes housing violations are civil that you can be arrested for, immigration offenses.
What type of traffic violation?
So you can be arrested for example, you can be civilly stopped if you do reckless driving.
No, so you drove recklessly. Now you're going to the courthouse to testify on some other issue, and at the courthouse you're subject to be stopped and arrested.
Right.
No,
Yeah.
I don't understand that.
Okay,
how
sure.
would that happen?
So here's how it would work. So right now, let's say someone was victim of violated some sort of reckless driving offense.
Yes.
The cops have been trying to find them.
FTA, failure to appear.
So what we're saying is, if someone is there because they are trying to access justice in some kind of way, they're either testifying on trial, they're receiving some of the services that Ms. Shaw outlined. We're simply saying they should not be arrested or stopped for whatever those other issues are while they're physically present at the courthouse. So if officers need to find them later to make sure they're no longer a threat to other people on the roadway, they can do that under the bill. And if they're a current threat to people's public safety, so for example, if it looked like maybe they were drunk driving on the way to the courthouse and they're a threat to public safety because they can get back in their car, they can be arrested for that. And if they violated some sort of criminal law, they can, again, criminal warrants are totally valid under the bill inside of courthouses. We're simply saying for civil warrants where someone can be arrested and stopped, it should not be carried out within the physical facility of the courthouse.
Like, for example, a failure to appear.
I'm not actually as familiar with failure to appear and whether you can be civilly stopped for that or not.
Okay, thank you very much.
Delegate Cardin.
Thank you, Madam Chair. Thank you, Delegate Stewart. Start a preface with, I really kind of like this bill. If there's a big trial going on in the courthouse and it becomes apparent with the news that so-and-so and such are going to come and testify in favor for the defendant or against the defendant, would this bill stop them from being able to be handled in that way or detained?
Could you explain further?
So they're there.
They're there to testify in a trial.
They're there they're there for other reasons.
Right, they're witnesses or, right.
But there was knowledge that they're going to be there.
Right.
So, but they're not there in their own criminal matter.
They're not a party. is what you're
So
saying.
would
Does the
this-
bill apply to non-parties? Yes.
Right, would this impact them?
Yes, if this would protect them from being arrested inside the courthouse. And we want that. We want witnesses to not be fearful to, for example, aid in the prosecution of violent criminals. And we've had that happen. The Access to Justice Commission itself, which Ms. Shaw is from, back a few years ago, they did this massive study. And they said, are people actually not coming to the courthouse to testify against people who have committed violent crimes? And they found yes. Yes, so we want to make sure that people, if you witness a crime, or if you're trying to file something against your tenant, or if you're a landlord and you're trying to file something against your tenant filing against your landlord, trying to get a protective order against your abusive partner, we want, whether you're a party or a non-litigant, or just honestly there because you're trying to access some of the services, job placement services, trying to get rental assistance, whatever is bringing you to the courthouse, that should be a neutral space where you feel safe going.
One more question.
Sure.
So if you have a person coming to the courthouse, might need assistance, maybe doesn't have a driver's license, but regardless of why he's coming, family members of his are bringing him or supporting him or there, would this help and impact them if they felt fear in going to the courthouse, but in assisting him?
Yes. It doesn't matter the reason you're there. If you're physically present in the courthouse, if there is not a criminal warrant, a judicial warrant, or you're a threat to public safety, you can't be civilly arrested, no matter why you're there.
Thank you.
Now, when you say judicial warrant, you actually mean signed, like you said, by a real judge.
Correct. If there is a judicial warrant signed by a real judge, then you can still get arrested. I mean, and in that way, the bill is sort of narrow, right? But if you're a legitimate threat to public safety, listen, like, we're going to have to arrest you, right? But some of this other stuff where you're not a present threat to others, but you're still fearful because you could be stopped or arrested, like, broken taillights are less important than witnesses testifying against a murder, a possible murder, a murder defendant, right? And so it's just a matter of prioritization of justice.
Okay, Delegate Simmons.
Thank you, Madam Chair. I'm trying to adopt what's going on here. So scenario.
Sure.
Gentleman comes to court, whatever, he's a witness, he may have other things with the court.
Sure.
And he's before the judge. And the judge say, hey, how did you get here? And he says, I drove. And let's say the judge said he drove. Okay, your license is suspended. Right? Your license is suspended. And let's say now the judge says, okay, we're going to adjourn this to afternoon. And now he goes back to his car, he gets in it, and he goes to drive, and they arrest him. What do you think about that scenario?
I think that person would probably be screwed in two ways. One, the judge who was there and who saw that probably is going to sign a warrant for their arrest if he wants to, so that's going to be a judicial warrant. And secondly, in the scenario you described, the gentleman has now walked to his car. He is outside the bounds of the judicial facility. And as I mentioned with the sponsor amendment, my initial idea with this bill is let's have kind of a radius around the courthouse of like 1,000 feet. But the sheriffs, who I think you may hear from, and some other people said like, that's not really tenable because like what if someone does provide, what if there's like a public drunkenness issue on the courthouse, sidewalk outside the courthouse. Has nothing to do with someone actually going to the courthouse. They weren't going there. It's not the kind of situation I'm talking about the bill. Now what? We're going to essentially stop officers from making valid civil arrests. That's not the intent of the bill. So we're going to limit it with the sponsor amendment to just the judicial premises, the facilities themselves, which means that the gentleman in your hypothetical is out of luck because he walked out to his car. That's out in the parking lot. That's going to be outside the judicial facility, probably. Now, if it's an underground parking lot, that actually probably would still be the judicial premises. But again, the judge would have already signed the warrant, so he's out of luck regardless.
Is screwed a legal term?
I believe so. I think if you look in the Black's Law Dictionary, the 7th edition, you believe you'll find the word screws. Yeah, from the original screw us. Yeah.
All right. Yeah. Delegate McComas.
Just briefly, let's say there's a trial and it's a murder trial.
Yeah.
Okay. And so this guy has an FTA, failure to appear.
Yeah.
And he's been subpoenaed. Somehow they caught the dude, got him subpoenaed that he has to appear because he's a material witness to it. If he goes into the courthouse, but he's still got this failure to appear, can they arrest him?
Yeah, because that's probably a judicial warrant that's been signed by a judge. Yeah.
Okay. All right then. And then what if it was a domestic violence, and there was a, they were trying to serve him, and there's not a warrant, but there is a subpoena to serve for him. They could, and he had to testify. So we'll use the same circumstance, and he goes into the court. They could not serve him with
They could
that.
serve the subpoena because that's not an arrest.
Okay, all right, okay. All right, thank you.
Delegate Ericon and then Conaway.
Oh, no, it's not me. Oh, sorry. Nope, I got no questions.
It looked like it was on you. Delegate Moreno.
How do you define a mile? Is it from the center of a building? Do you just pop it in and address it in the GPS?
We don't define it anymore. It's out of the bill.
It's out of the bill.
It's just the judicial facilities. Now, we're going to take that out because, like I said, you'll hear from the sheriffs. Like, I think that saying a mile or 1,000 feet or a radius or whatever, I think that makes the law enforcement's job too difficult to figure out who's there for the real courthouse, who's not. I think they had a great point. So we're just going to take out the whole radius thing and just say the judicial facility themselves, the actual, owned by the courthouse. Courthouse steps still counts because that's part of the courthouse, right? A parking lot that's attached to the facility counts. But if you park down the street, you find a good street parking spot, a block or two down, you're no longer on the judicial premises. And so you don't have any protection under the bill.
Okay, is there a loophole where some law enforcement could park reasonably a certain distance away?
Yeah, there is.
Okay, all right.
Yeah, I mean, they could still do that. Again, I think it's a pretty narrow, reasonable bill. Absolutely, like law enforcement, if they still want to come after someone, there are ways to do so. But I think that we still have that modicum, at least some modicum of protection in this bill that we don't currently have, so that people feel safe to have their rights vindicated without that fear of arrest.
All right, thank you.
Delegate Conaway.
Thank you for the second chance here. So, Delegate, you're saying the front steps would not be considered as common ground, it would still be considered as the property?
Yeah, it would be. Because, I mean, if you said, like, let me get the blueprints for the courthouse.
What about the sidewalk? I understand what you're saying.
Yeah, the sidewalk would
so in other words,
not be the facility.
So in other words, I would think that the average officer, if they found out that you had a warrant for your arrest, they would just follow you outside until you get off the steps, and then they would arrest you.
They probably would.
And that would be okay with you?
It's not necessarily okay with me, but I think that what the bill represents with the sponsor amendment is the best we can do. I would love to have some sort of larger catchment area and make it work so that officers can't do that sort of thing. I also will note that in New York and Oregon, they passed a version of this bill that said that if you're on your way to your vehicle or you're on the way in from your vehicle, that you also have protection as long as you're trying to basically like either get home or get to the bus or get to your vehicle. Okay. Obviously, this bill is now in the purview of the committee now. One option, if you didn't want to go with sort of a foot radius approach and you wanted to say that if someone is coming or going to the courthouse, they cannot be arrested under the same auspices as this. If that's something you guys are interested in, I can certainly submit that language that the other states have passed because, yeah, I'm with you. Obviously, it seems like an obvious loophole.
No, I'm not with you. I think that law enforcement should arrest you if you show up on the premises or if you don't. So, but I thank you very much for offering the bill.
Okay. Delegate Phillips.
Thank you, Madam Chair, and thank you, Delegate Onstool, for bringing this bill. And I like the bill, the intent of the bill. But I'm looking at subject to civil penalty, or only subject to civil penalty. And that is a really narrow kind of a piece. Mm-hmm. Because often, you mentioned failure to appear as an example, Conway. That is subject to civil, but it could be subject to criminal as well.
Correct.
Driving on a suspended license could be civil, but it could be criminal as well. So I'm trying to figure out the distinction, and my sense is the intent is if I have a minor violation, we don't want people to be afraid to come to court.
Sure.
But the way I read this, I consider those relatively minor violations, but it doesn't stop one from being arrested.
Yeah. So I would say two things. Very good point. I would say number one, we can send you a list of the types of offenses that are purely civil that would fall under the bill, if that's helpful. And number two, you obviously raise a good point, which is that, I mean, again, if the committee's will is to broaden this further to more types of offenses, I'm certainly not going to complain. But I tried to bring a product before the committee that was narrow and intentionally, purposefully narrow. To just the most minor of offenses, because, you know, if someone really is a threat to public safety, if someone really is a threat, I think they should probably be, I mean, to Delegate Conaway's point, I think they should be arrested anywhere. And so we're really trying to focus on the most narrow possible offenses here so that people feel safe participating. We're not picking people up on tic-tacky things so they can be part of the justice system and be guaranteed that access to justice that should be every Marylander's right, but without harming public safety. But if it was if the committees or the subcommittee wanted to find or wanted me to throw out some ideas of some ways to broaden that out a little bit more, I'm happy to do that.
I'm just trying to figure out ways to make sure it's practical. Because if I'm a law enforcement officer and I know someone's coming to court and they've been involved in a criminal matter and they've been convicted or they are a warrant, that's one thing. That's an easy one.
Sure.
But if I'm not sure and the person is in court, that distinction between civil versus a minor criminal, I'm just trying to think through the practical application of all of this. But thank you for bringing the bill.
Appreciate it.
Seeing no further questions, we don't have Ms. Feldman online? Okay. That concludes the favorable testimony.
Thank you all.
Thank you. We're going to move on to favorable with amendment online. Amir Naviwala. Okay. All right. Mr. Naviwala, whenever you're ready, we're going to move on to favorable with amendment online. Amir Naviwala.
Good afternoon. Good afternoon, dear Honorable Chair Bartlett. Am I on?
All right.
Good. Okay.
Mr. Naviwala, whenever you're ready, move on to favorable with amendment online.
Can you hear me?
Naviwala.
Yeah, can you hear me? Good afternoon. Good afternoon, dear Honorable. Sorry, one second.
Oh, he can't see this. Can you see this? You have to turn off your online.
Yeah, I just turned it off. I'm sorry about that.
Okay,
Yeah, it was
great.
giving
No
feedback.
problem.
My bad. Yeah. Dear Honorable Chair Bartlett, Vice Chair Davis, and members of the committee, my name is Amr Naviwala, and I'm a candidate for County Council in Howard County. I testified today in strong support of HB 309, which stands as a defense of constitutional rights and for integrity of our courts. When immigrants fear arrest just for attending court, justice is compromised. The ability to face legal proceedings without intimidation is a fundamental pillar of our due process. The practice of courthouse arrest has driven many to avoid hearings out of fear, eroding the justice system itself. HB 309 addresses this by prohibiting civil enforcement within a radius around judicial facilities. Yet 1 mile is insufficient. ICE agents can easily wait just beyond that boundary. To ensure safe passage home after court, the radius must be larger, encompassing the full realistic scope of travel. I urge you to pass HB 309 immediately, even as it stands. It is essential to restore faith in our judicial system. But let us not stop there. I strongly urge an amendment to expand the protected radius, ensuring that no one is tracked and detained just outside an arbitrary line. We must do better for all our residents. Pass this bill now and ideally strengthen it to fully protect those who desperately need it. Thank you for your time.
Thank you. Are there any questions? There's one. Delegate Conaway.
Thank you, Chair. Thank you, witness, for coming in to testify. So when you said immigrants might be arrested for what?
So my understanding is this is on civil minor offenses. And so am I understanding that right? Your question correctly, that you're talking about?
My question is, you said immigrants might be arrested, and I want to know immigrants might be arrested for what?
So my understanding is you're discussing civil and minor criminal offenses. Is that correct?
Yes. What kind of offense might an immigrant be arrested for?
So what I'm not full. So in general, what I'm not understanding is what are the types of scenarios under which they?
I don't know. Did you mention ICE? Did you mention ICE?
I did mention ICE. Yeah.
Yeah. So is this an anti-ICE bill?
I see this as it should be an anti-ICE bill. Yeah.
Okay, thank you so very much.
Yeah. Thank you. Yeah.
Thank you. Okay, that concludes the testimony for House Bill. No, it doesn't. I apologize. We have one person who's testifying unfavorable, and that is Daniel Franklin. And Mr. Franklin, I don't know your rank, so therefore all I have is Daniel Franklin, but obviously there is a rank attached to your name.
All right. Well, good afternoon, Chair Bartlett, Vice Chair Davis, members of the committee. As the chair said, I'm Daniel Franklin. I am the Chief of Police for the town of Morningside in Prince George's County. I'm here today in front of you on behalf of the Maryland Chiefs and Sheriffs Association asking for an unfavorable report on House Bill 309. First and foremost, House Bill 309 places a standard on law enforcement that's unfavorable to maintaining law and order and also to protecting many constituents from many quality of life offenses. One of the things that stands out to me is this law could prevent law enforcement from stopping someone to serve them with a civil protective order. That is problematic from a domestic violence standpoint. The bill currently reads that the law enforcement cannot stop, arrest, or detain in or within 1,000 feet of a judicial facility for an alleged or adjudicated civil offense that is subject solely to a civil penalty. I understand the amendment because one of my questions was going to be how were we going to determine that 1,000 feet? This bill is also problematic in the state of Maryland because there are many judicial facilities that house many other agencies. Let me throw Caroline County for an example because I spent many years there. There is parole and probation, social services, and many other entities in that building. You have more than just court attending folks come and go. The other thing that this bill might do is it would prohibit the very reason for some of the screeners at the front door. A lot of this, significant amounts of marijuana. If someone were to light up a cigarette in this building, according to this, we can't do anything about it. That's, again, it's going to discourage proactive public safety practices due to the fear of litigation against law enforcement. The other thing this does, this will create hesitation in many law enforcement officers to act. In our profession, that's fatal. I have so much more that I could say, but I hear the buzzer, so I will thank you all for your time. For these reasons, I ask for an unfavorable recommendation.
Delegate Erican.
Thank you, Madam Speaker. Chief, would you like to share the other few reasons that you wanted to share with us? We'd like to hear them.
Okay. If that is pleasurable to the committee, I will gladly. Some of the ones that, again, the possession of cannabis more than a civil amount, I know that's not the end of the world, but that often leads to other things. The traffic violations that were referenced previously. So according to the way that this bill is interpreted, if someone commits a DUI offense, drives to court intoxicated, it's like a finish line when they hit that threshold of the front door. They would feel that they were home free. The whole concept of that, again, I understand the amendment that's afoot, can appreciate that. I can understand the spirit of the bill and what's trying to be accomplished. The other thing would be, suppose you had someone walk in the front door of a district court building with an open container of alcohol. According to this, you can't stop them. I just find this, like I said, I find this bill very problematic for many, many reasons.
Sure. You have another question?
Yeah, that made me think of a question. Okay, so your interpretation of the bill is that, right, it doesn't just tie the hands of law enforcement, essentially external law enforcement who would be coming in, but in fact, people that actually work at the jail who do that kind of screening, like let's just say there was a gal who accidentally forgot her backup magazine in her purse, for example. I don't know anybody that has ever done it, but let's just say there was a gal who had perhaps done something like that. They couldn't stop me since it's not a crime really to do that, but it's not allowed. But if they stop me, they could violate this rule. Maybe they could write me a citation, I guess, but it wasn't.
I would say you're correct.
theoretically, obviously.
Right. In theory, I would say that you are correct.
Okay, all right, well, this is a little muddy water then, okay, thank you.
Thank you. Okay, so let me just ask a quick question. And I think I know the answer, but I just want to know.
Yes,
So
ma'am.
is it often that people come in with an open container, to your knowledge, to a to a courthouse?
I have been in law enforcement 25 years, and believe it or not, I have seen it on 4 occasions where someone brought an open container. One time they were drinking it, 3 times they had it concealed.
Was it medicinal? No, I'm just joking.
If it is, ma'am, sign me up.
Come in with a doctor's note. Okay, I'm going to start with Delegate Valentine, please.
Thank you, Madam Chair, and thank you for coming in to testify today. Your statement made me start to think about the different judicial facilities throughout this state, and by that I mean when you brought up Caroline County, I got to thinking about Frederick County and Garrett County. Garrett County, the jail is located in the courthouse. That is where it's actually located, the sheriff's office itself, as well as the jail, also the Board of Elections, the Maryland Comptroller's Office, several different entities that would have nothing to do with the judicial hearing. So I just wanted to thank you for that. And what's the question? Isn't that so? Isn't that so? That there are a lot of different facilities that this would be problematic. Isn't that so?
Yes, it is, sir. And again, I was drawing on Caroline County because that's where I retired from. I'm currently employed in Prince George's County. The commissioner's office is inside the jail.
Okay, all right. I'm going to keep going here. We've been on a roll. Let's keep our roll going. Delegate Embry.
Thank you very much. In Baltimore City, our sheriff, who is responsible for circuit court security, has issued an order that ICE agents, who sometimes have non-criminal warrants, are not allowed inside the courthouse unless they have a judicially signed warrant. Are you aware if that's true anywhere else, and if any other courthouses have similar?
I am not aware of any other facility that practices that.
Okay, thank you.
Thank you, Madam Chair. Thank you very much for being here. You're presently employed in Prince George's County, correct?
Yes, sir.
Do you often go to the courthouses, either the district court in Hyattsville or the circuit court and district court in Upper Marlboro?
I would say I spend most of my time in Upper Marlboro. Occasionally I venture to Hyattsville.
Okay. When you go to Upper Marlboro, there's a side entrance that law enforcement can go through, and lawyers, isn't that correct? That you go through?
To the best of my knowledge, it's the commissioner's entrance is what they call it,
Okay.
but yes.
Have you ever been through the public entrance up on off Main Street?
No, sir.
Okay. I have been to Prince George's County, both courthouses. I've been to Baltimore County, all 4 courthouses, Baltimore City, all 6 courthouses. Every single one, you're not allowed to, you're prohibited from bringing any liquids in, kind of like at the airport. Isn't that true in Prince George's County?
100%.
Okay. So if you had an open container of alcohol, they would make you just throw it out right then and there, right?
I think this bill would prohibit them from doing that because there's nothing criminal associated with it.
Okay, so they're not permitted to tell you to get rid of, this bill would prohibit them from saying you can't, you have to throw away that drink?
To the best of my knowledge, yes, because that would constitute a citizen stop.
Okay, so if I put my bag, I often do, put my bag through the metal detector, and everybody who goes to the public entrance is required to put their bag through the metal detector, right? And if I happen to have, now as my colleague from Hartford County knows, I don't have any guns, I don't have any magazines, but if I had my extra magazine in my briefcase, and I went through the metal detector and they saw that, are you saying that they wouldn't be allowed to take away my bullets?
My interpretation is because that is a civil violation, because it's not something that's illegal to possess, they would not be allowed to stop or detain you for it.
Okay. And my last question.
Sure.
I think that you're misinterpreting it, but we'll figure that one out maybe later. Are you here representing the chiefs and sheriffs, or are you just representing yourself?
Chiefs and sheriffs, sir.
Okay, got it. Thank you.
Thank you. Delegate Phillip.
Thank you, Madam Chair. And I'm going to ask you to help us through this process. So the intent is to ensure that there's no chilling effect for coming to the courthouse, right? Intent of the bill. Would you agree with that?
I don't know the full intent of the bill, to be 100% honest with you, sir.
Yep, and I'm going to take it both in the context of potentially ICE agents, as Delegate Embry asked you specifically about what's going on in Baltimore City, but I want to be more broad. If, in fact, the objective is to make people feel safe about coming into the courthouse without being arrested for what I would consider a minor infraction, is there a recommendation that you as law enforcement would have so that we don't have this chilling effect of people being arrested in the courthouse?
I don't want to, I'm here representing an organization, but without speaking to the membership or the executive committee, I don't want to commit anything there. My personal opinion is that there could be some significant amendments, and it would possibly make sense if those amendments were made. My loose interpretation of it personally, again, not from the organization, is that this is designed to not allow ICE to do their enforcement inside of a judicial facility. And if that is the case, we as municipal police in Maryland, we don't deal with immigration violations. So that's something that we don't have a dog in that fight. To be 100% clear, again, that is me interpreting, that is not the organization speaking.
So you did offer up, and so I would love to get the chiefs and police perspective on assisting us with getting to the intent of the bill, which is to avoid persons being arrested at the courthouse, particularly those who feel that arrest would chill them from coming into the courthouse. So thank you.
Thank you, and that is our subcommittee chair for criminal law, which is where this bill would be reviewed if it is to go to subcommittee. Delegate McComas?
Yeah, I had an opportunity, and it just seems like we're going this way on this thing. A gentleman was subpoenaed to testify in Baltimore City Circuit Court, and there were some guys that were sitting in the back of the courtroom, and all that testimony just disappeared. And so the investigating officer said, why did that disappear? Well, because if I testified against them, against the person, the minute I got out of the courthouse, I'd be shot dead. Okay, so what I see we're doing here is folks that, might do something not major, but it seems to me we're worrying about people having minor issues, and then the people that are called to testify to try to take bad people off the street, they have no protection. And so the guy was like nervous as a jitterbug, okay, and basically he just couldn't remember anything. And these were folks that had smoked somebody in the situation, killed them. Right. So I don't understand, because all I see, and I'd like your thought about this, I just see total chaos in the district courts. People coming in, and you've got to, I know you have to go through the detector, metal detector, and you can't use a badge anymore, that you're a lawyer. They check your stuff. You're lucky if some of the guys know you or if they don't, but the thing is, you just follow the rules and go in, and I think this is just going to create a lot of chaos. And I'm not sure that that's what we want in our courthouse, because the district courts, they like to move stuff along, and so I just kind of want your thoughts on that. I mean, isn't that so? I mean, or is it not so? One or the other.
Yes, ma'am, I agree with you on that. And the other part of it is, speaking to that type of scenario that you spoke of, where the witness intimidation was taking place, albeit wasn't broadcast, but you were able to see what it was for what it was. At that point in time, should this pass, do they send somebody to the front door who is, going to create a civil issue to take the court security off of their game as a distraction? Is that far-fetched?
No.
Not as far-fetched as some think.
No.
But again, not representing the organization with this, but this, to me, this appears to be a blanket solution to an acute issue. That's what it appears to be.
Well, also, I think maybe it's too bad we didn't have the judiciary weigh in on this, because I know Judge Morrissey's been very concerned about the safety of all the district courts.
Yes.
And
They have testimony.
Pardon?
They have testimony here.
Okay, is it pro or con? It's what?
Info.
Okay, right. Anyway, I just think this is kind of a problem that it's important to the folks that might have minor things, but I think as far as the running of the system, I suspect, isn't that so? It's going to have problems.
Agreed.
Sorry,
Thank
Madam
you.
Chair.
No, you did fine. Delegate Mangione.
Thank you, Madam Chair. Thank you for being here, sir. I'm not a lawyer, so I'm not exactly sure how often some of these situations are occurring, but my understanding is that civil violations, I mean, you're not normally getting arrested, right?
Normally, many civil violations, you can be arrested for certain civil violations, but most of them are going to be a civil type citation.
For not paying the citation or not?
Where it'd have a monetary fine.
I guess, how often is this happening if you take away, say, the immigration issue? Is this something that occurs a lot at the court where these arrests are happening?
The thing that I can testify to, because I'm familiar with, is, again, I'm going to go back to Caroline County, where you have parole and probation, right? So they have to come in the front door, and the hallway is to the immediate right to go to parole and probation. So should you have someone that has a body attachment, you may not be able to pick them up, because that technically it's technically civil. A body attachment is, or a show cause, you technically can't stop them to hand them a show cause order. That's, the stop and detain are two very different things, is the way I'm reading this. So the problem becomes, I feel, the stopping part is probably the biggest issue here. But again, when someone comes and is, to speak to what you're asking of these other violations, I think because there are currently prohibitions and screeners and things to combat things of this nature, no, they're not taking place because people are obeying them.
So if you take away the illegal immigration issue, this is not something, it's not a huge issue, is what would you agree with that?
I think the current safeguards prohibit it from being a huge issue.
Okay. I'm just trying to better understand what I think the intent of the bill is, but I mean, and I'm not trying to question the bill maker. To me, it seems like the entire discussion of this bill, if it's not, according to what you're saying, a huge problem that the state of Maryland is facing, is based again on the immigration discussion then.
That's the way that I am interpreting it, yes, sir.
Thank you.
So could you get us how many arrests are made in the courthouse? And how many arrests are made near the courthouse?
I don't have jurisdiction currently of any courthouse in my current job.
Maybe the association?
We could certainly ask just speaking from Prince George's County, that would be county PD and county sheriffs. So I could certainly make an inquiry.
Okay, great. Thank you so much.
If someone would send me what they would like as an inquiry, I will gladly get it submitted.
That's actually the inquiry.
So just how many were made in and around?
Yes. And I'll give you a date range. I'll say within the past 2 years, because I know we don't want to go indefinitely.
So arrests in and around.
Yes, please.
Got it.
Thank you. Okay, Delegate Conaway.
Thank you, Officer, for coming in to testify. In reference to people being stopped, how often are people stopped coming to the courthouse?
Everyone that comes through the door, to my knowledge. They have to be stopped and screened.
And so if they have a civil offense pending, how would you know that?
To my knowledge, unless they were informed of it ahead of time, they wouldn't know that. If they said so-and-so is coming in and they have a body attachment, maybe. But as far as that goes, I think it would require a record check. This would more, what we're concerned about is the on-view offenses that are being committed.
Okay. Thank you so very much. Thank you.
Thank you very much. All righty. I believe that concludes our testimony for House Bill 309. Thank you, Chief.
Thank you for your time.
I should have known by all those bars. All right, we're going to move to Delegate Boucher. And Delegate Boucher, it looks like it is you and
Yes.
only you.
Yes, ma'am.
And
I
you-
must say, I feel a little bit nervous having told Valentine the other day when he came up to give you a hard time.
That's right. All right, don't be nervous, but be very much afraid. Okay, whenever you're ready.
Thank you very much. Good afternoon, Chairman, or Chairwoman, and Vice Chair, and my distinguished colleagues on Judiciary. It's a pleasure to be here in front of you with this bill. This is a very important bill. And for the record, I am Delegate Christopher Eric Boucher, District 5, representing Carroll and Frederick counties. Don't hold that against me. I humbly solicit your support of HB 165. Sheriffs are a state constitutional position with local-only jurisdiction for the administration of public safety, the same as state's attorneys within the same jurisdiction. We as members of the General Assembly in our delegation duties are responsible for setting the salary in local-only legislation. In consideration of sheriffs and counties where they are the primary law enforcement, I emphasize that some counties, the sheriffs are not primary law enforcement. This bill affects strictly primary law enforcement sheriffs. The salary of the two critical public safety offices should be in parity. This will not only standardize their compensation evenly, but also reduce by half the bills needed to set salaries. For simplicity of expectation and fairness to the position of sheriff, their salaries should be the same. They work very closely together, and I experienced that as a county commissioner and now as a delegate for Carroll County. The submitted written testimony of the fiscal year 2025 salary data shows a clear imbalance in how public safety leadership is valued across Maryland. Police chiefs earn the highest compensation on average of around $252,000 annually, far exceeding both state attorneys at an average of $187,000 respectively, and sheriffs at a mere $102,000 annually. Even though sheriffs are constitutional officers who carry equal or broader responsibilities serving as primary law enforcement authority in their counties, sheriff salaries vary widely and are consistently lower than those of appointed police chiefs and state's attorneys. Excuse me. Suggesting systematic undercompensation that is not in line with their authority, accountability, or workload, and highlighting a structural preference for higher paid appointed leadership over elected officials. I wish to clarify so submitted opponents understand that this bill in no way requires all sheriffs and state's attorneys statewide across the state have the exact same pay. The authority would still be in that local jurisdiction. For an example, if St. Mary's County pays their sheriff and state's attorney both $200,000, it does not necessarily mean the same applies to all other counties. It would still be within each individual county to set the parity. Thank you.
Thank you. Are there any questions? I can always hear the Jeopardy song in my head when I ask if there's any questions. Delegate Simmons.
Thank you.
As long as I don't get the buzzer.
Yeah, right.
Yes, sir.
First of all, did you have anything further you wanted to add?
I like the fact that this is an autonomous thing and still leaves the discretion within the local delegation, which is very critical. Yes, sir.
Okay, thank you. So can you explain out a little bit more about where the authority lies for the increase in salary or the pay?
The authority lies for the sheriff within each delegation, such as we had a controversy 2 sessions ago over the Carroll County Sheriff increase. So that was a local-only bill.
Sure.
So the local delegation would bring the bill forward to set the salary. So it'd still be within their jurisdiction. They just determine what level they'd want it.
This is beautiful because I'm doing it here in Anne Arundel, so
Good.
let's get this across.
I'm fearful of Delegate Cardin.
I'm just curious, so the Chiefs and Sheriffs Association does not take a position or does take a position?
They supplied information. I think their biggest concern, I emphasized in the end about the clarification because I think some of the opposition, along with MACO, did not catch on to the fact that this only applies to the counties where the sheriffs are primary law enforcement. So some of them had a negative attitude, and they thought that this would take the authority away from the local delegations. This bill doesn't do that at all. It still keeps that authority within the delegation to bring to parity.
Right, so the delegation still required to vote to increase the salary, but they're required to vote to increase it to be parity with the state's attorney?
Yes, sir.
So are we taking away the authority or not? If we're forcing the delegation to vote to do what the bill says they have to do?
Well, in a way, I'd see what you're saying, but it still gives the authority within the delegation to set it. They can determine the state's attorney salaries levels too, as long as they bring in a parity. I think the most important thing is if you look in the data that's submitted, the sheriffs are making way too low of a salary in compared to what their service is. I'm looking at this as a creative way to try to bring them up because they consistently are lagging behind. And there's a bit of a negativity out there right now with sheriffs. And I think it's reflected in how low this pay is. I'd like to bring that up in parity. I'm willing to see amendments on this bill. You can be creative. There's a lot of brilliant minds in this room. I'm one of them, I think. And I'd like to see you guys chew on this. You know, I don't have all the answers, but I think this body has enough people in it where they could try to work this into something feasible. Thank you.
Thank you, Madam Chair. And thank you, Delegate, for bringing the bill. And I know we've talked about this bill a little bit previously, and I was just concerned or curious. I think I counted 16 counties this would affect. How many of those counties have you personally reached out to kind of get feedback individually from counties or support from those counties that are named?
Well, I will be quite frank with you. I thoroughly believe most of the sheriffs are for this. Obviously, you see why. However, there are sheriffs that have been able to set their salary linked to such as the lieutenant colonel of the state police, which accelerated their salaries above their counterparts. And they are fearful that this could potentially degrade them or bring them down. But the numbers I've seen, I don't think will. So what I've solicited to the sheriffs is be the brotherhood to one another. You see your colleagues suffering with such low wages that they should be brought up and they should stick together. But there's, like I mentioned before, there's negativity out there against the sheriff's department. And I think the sheriff's department and sheriffs, after seeing the bills we just passed, are actually laying low on this. So I feel a little bit out in the wind on my own on this. Prior to that point, I felt I had support. Behind the scenes, I'm sure they very much support this.
Madam Chair? Just to follow up, not the sheriffs themselves, but what about the funding mechanism, say the Board of County Commissioners or such in each of those counties? Have you had any discussions with those entities? I'm curious.
None of them have come forward and voiced any negativity against it. I think, in a way, it's been good that things are quiet considering the controversy around it.
Thank you. Thank you, Madam Chair.
Thank you. Delegate Moreno?
I just want to go on the record and say that I love my sheriff in Howard County, Sheriff Harris. But so all sheriffs run for office, correct?
I believe so.
So if you know what the salary is, why would you want to run for it if you also know what the duties are? Wouldn't you just find another job that pays you more?
Well, some of these sheriffs retire from another occupation before they do that job. Also, they're aware that after a 4-year cycle, the raise can come because you can't have a raise like us within your term. So there's always a hope that legislation will be brought forward.
Wouldn't it be better suited for like the localities, like the counties, to kind of work on salaries instead of across the board? Is that what you said? Did you already say that? Okay. I was like, did I miss your question?
Well,
Oh, to you guys, okay. Yeah. You guys are real loud, that's, I think I, maybe,
Okay, hold on, let's
I'm
go
sorry,
ahead
I'm
and answer.
sorry, yes.
Sure,
Well,
go ahead and answer.
legally, it lies in the jurisdiction of us. It's their jurisdiction to cover. And I don't think it's our responsibility as state legislators to hand that responsibility off to the county. Even though I was once a county commissioner and complained a lot about unfunded mandates, this is a state constitutional position and it should exist within our authority.
And one last question, why choose for the salary to be on level with the state's attorney, not the clerk of the court or the register of wills?
That is a very good question, and I had mulled this around for a couple years. I'll divulge too. The idea of this came about my freshman year when I talked to former Chair Clippinger, who works as a state's attorney, and this is a conundrum that keeps facing this body with all these different bills. And I got to thinking about it. What other office is close to it in constitutional duties and jurisdiction? And I concluded that the best one would be the state's attorney because I see how well those two work together and execute in their jobs. I thought potentially maybe we can link it to a district court judge, which I think one county does. And one county links it to the lieutenant colonel of the state police, which I'm totally against. And the reason is the jurisdiction of a sheriff is a county. The jurisdiction of a state trooper, a lieutenant colonel, is statewide. It's complete apples to oranges and does not coincide with one another. So we need to bring that back into the county jurisdiction. And I thought that the state's attorney would be the best comparable office to link it up with.
Thank you.
Great. Thank you, Delegate Boucher.
Thank you. That one pretty easy. Thank you.
Yeah. Come back, there'll be more later. Delegate McComas had a question? Hold on.
Well, I'm actually going to tell a story, but it's going to be, isn't that so? You want to hear the story?
Hey.
Isn't that so, is it?
Isn't that so?
Listen, you all sit right next to each other. Tell the story later, okay?
No, I think everybody needs to hear the story.
Let's tell it.
It's a policy issue.
Tell that another event.
Right.
Okay, Delegate Grammer, House Bill 365.
Thank you, Madam Chair.
Thank you for your cooperation, Delegate McComas.
I was reminded why I like this committee so much listening in. I was thrown off. I had no choice. I don't have a panel, but I'd welcome anybody who'd want to join me.
Okay, and welcome back,
Thank you.
Delegate Grammer. We have, for information, we have Mark Pennock.
I'll get started if it's pleasurable to the committee.
That sounds fine, thank you.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 365. House Bill 365 protects the firearm ownership rights of those who qualify to use medical cannabis by reconciling the articles concerning health and public safety. A loophole continues to exist between the laws governing our medical cannabis industry and the laws governing our state police. Currently, patients who qualify to use medical cannabis, a legal product, through Maryland's legal medical cannabis certification, lose their rights for answering the relevant firearms forms. If you have a card or even the simple administration-issued identification number, you lose your rights. You need not purchase, possess, or use cannabis. Your status as a qualifying patient, per the current procedures followed by the state police, prohibits a legitimate purchase. When asked for an opinion, Attorney General Brian Frosch wrote that state law does not permit the state police to deny applications for purchase, handgun qualifications, or carry permits. He recommended that to clarify this issue, the state legislature should reconcile the articles concerning health and public safety, and that is what this bill does. In a previous year, combat veteran Josh O'Neill testified in support of this bill. He said that he carries a firearm as part of his employment and would like to use cannabis for pain management due to a combat-related injury. Ironically, he works for the medical cannabis industry. He described his addiction to pain pills for 2 years and his recovery. Quote, "I'm in horrible pain every day. I sleep about 2.5 hours every night. I just want to sleep." Hunter Biden's case was supposed to resolve this issue, but he received a pardon. Maryland qualifying patients need protection, and we need to provide the leadership to protect them. It makes no sense if qualifying patients in Maryland cannot legally purchase a gun, but can legally carry one. We should pass House Bill 365 to protect the rights of those who use non-addictive medical solutions. Happy to take questions and ask for a favorable on House Bill 365.
Thank you, Madam Chair. Mark Pennick, President of Maryland Show Issue. You have my written testimony in front of you that highlights all the legal issues associated with this. All those legal issues are because of federal law. In federal law, marijuana is a Schedule I drug. It has no legitimate usage as long as it remains on Schedule I of the Controlled Substances Act. That's the harsh reality, and that means that there's a federal prohibition, a disqualification on the possession of marijuana, including medical marijuana. President Trump, in December, signed an executive order that directed the federal agencies to move marijuana out of Schedule I to Schedule III. And that is simply the drug like codeines that requires a physician's prescription, and it removes all the federal issues described in my 9 pages of single-page testimony. So if that is actually implemented, this bill should pass. But it's a big if, because until it is implemented, every person with a medical marijuana card and found in possession of a firearm can go to prison, federal prison, for 10 years. So that's the big if. And that the state police do follow federal law when they issue carry permits and HQLs and purchases, because right now in a federal form 4873, medical marijuana users may not purchase a firearm, period, full stop. And if you lie on that form, you go to prison for 10 years under 18 U.S.C. section 922A6. So that's the reason that we have the conundrum. Moving it off Schedule I into Schedule III solves that problem. I'm happy to take questions.
Great, thank you. Quick question. Are there any restrictions for any other current Schedule I drug with respect to the purchase, ownership, or possession of a firearm, or carry of a firearm?
Yes, any Schedule I, by definition, is a drug that has no legitimate use. And thus, being a user of a Schedule I drug is an equal disqualifier. Thus, Schedule I drugs include things like heroin, cocaine, those kind of LSD, for example, are Schedule I drugs. So moving out of that category is what the executive order directs.
So if and only until the federal government moves it out of the Schedule I category, it is still a violation of federal law to possess medical cannabis and as well as recreational cannabis?
Correct.
Okay, just wanted to make sure I was clear on that.
Oh, absolutely. This is very complicated, which is why you have 9 pages of testimony in front of you. Mm-hmm. And there's a case in the Supreme Court right now, it's called Humani versus United States, that where the constitutionality of the federal prohibitor, 18 U.S.C. section 923 G3, is presented to the Supreme Court on an as-applied challenge. So for the legal nerds among you, you might have fun reading all that stuff.
Yeah, I'm looking it over right now, and it's very interesting. Okay, I see no questions. So that concludes the testimony for House Bill 365. Thank you, Delegate.
Thank you so much.
Thank you, Madam Chair. And
members, that concludes our bill hearings for today.
Oh my God.
And the sun is still shining.